worker. You may proceed.
Thank you, Honorable Deputy Chairperson. I move on behalf of the African National Congress that in the next sitting of the Council debates the decriminalization of sex work. On Friday, 11 March 2016, the Deputy President released a detailed health plan to ensure that sex workers have better health care. The plan indicates that sex workers will now receive antiretrovirals as soon as they test HIV positive. The Global Fund for HIV, tuberculosis, and malaria has allocated about 200 million rands to fund this health plan. The Law Reform Commission, which investigated whether the law that makes sex work or adult sex work illegal has to be changed, held hearings in 2002 and accepted submissions in 2012. The comments from the NGOs that work with the sex workers were very positive about the plan, but they all agree that the health plan without decriminalization was going to be limited in effect. I therefore move that the House debates the decriminalization of sex work. I so move.
Honorable Van Lingen.
Honorable Chairperson, thank you for the opportunity. On behalf of the Democratic Alliance, I hereby wish to move a notice of a motion that the Council notes that the Eastern Cape Department of Basic Education had to return 530 million of its infrastructure grant to National Treasury as unspent funding. It is clear that it is a clear indication at national level there is recognition for the urgent need for facilities in this province. However, at provincial level, there is no effort or there's a lack of implementation, construction and provision of such facilities. A good example is the Jeffreys Bay Comprehensive High School, which was opened with great fanfare in July 2015 as a technical high school, starting with grades 8, 9 and 10. Not a single of the 4 workshops have been built in this financial year. Nothing has been planned for the next financial year or the following financial year. For the province with the lowest matric pass rate in the country, which has dropped to a low for 2015 at 56.8%, despite the MEC's prediction of 75% pass rate, this is not acceptable. Urgent decisions will have to be taken in terms of the Eastern Cape Department of Basic Education's ability to manage this portfolio and its budget. We move that this House urgently debates the above. I so move.
Honorable Engelbrecht.
Mr. Chair, thank you. On behalf of the Democratic Alliance, I hereby wish to move with notice that this House debates the lack of water provision in the Hammanskraal area of Tshwane, with specific reference to the problems associated with the existing water waste treatment works in Tshwane. I so move.
Honorable Smith.
Honorable Deputy Chair, there's a misunderstanding. I thought it's first the motions without notice, so I want to withdraw.
Thank you very much. Honorable Shibagwa.
On behalf of the Democratic Alliance, I hereby wish to move with notice that this House debates the ongoing abuse of the elderly, of unauthorized deductions on the SASSA grant beneficiaries' accounts and their constitutional right to access the social security in terms of Section 27, subsection 1C. I thank you, Chairperson.
Thank you very much. Honorable Isaac.
Thank you, Chairperson, for the opportunity. Chairperson, on behalf of the Democratic Alliance, I hereby wish to move with notice that this House debates the corruption with the land administration sector and the economic impact of unproductive land on job creation. I so move. Thank you.
Honorable Tau, my surname is Hatting. On behalf of the Democratic Alliance, I hereby wish to move with notice that the House debate the concern that more than 650 million that should have been utilized for student loans and bursaries have 2 weeks before the end of the financial year not yet been allocated. And this is as we end of the first academic term. This is happening while students are not only protesting because of the lack of funding, but also while thousands of poor students are being left without the financial means to study and are being denied an opportunity to acquire a tertiary qualification, killing all hopes of a dream of a better future. I so move.
Thank you very much. We shall then now proceed to motions without notice. Honorable Engelbrecht.
Thank you, Mr. Chair. On behalf of the Democratic Alliance, I hereby wish to move with notice that this House congratulates Miss South Africa Candace Abrams from Johannesburg for winning the coveted Mrs. World title in China. Once again, a South African has reached her dream to educate, empower, and encourage. We wish her every success in the year ahead. I so move.
Is there any objection to the motion? Therefore, the motion is agreed to. Honorable Smith.
Thank you very much, Deputy Chair. On behalf of the Democratic Alliance, I hereby wish to move a motion without notice that this House notes that Mogalakwena, Mokopong, and Modimolle local municipalities are burning as we sit here today. Violent protests are plaguing these municipalities, and the mayors of these respective municipalities' houses were either put ablaze or were vandalized and sprayed full of sewer. This House call on the National Minister of COIDA, the MEC of Kokstad in Limpopo, and the Premier of Limpopo to immediately intervene to salvage this situation before it turns into anarchy. I so move.
Is there any objection to the motion? Therefore, the motion is not carried. Honorable Mtile.
Thank you, Deputy Chair. I rise on behalf of the economic freedom fighters and move without notice that the Council knows that the Gauteng Department of Health intends displacing at least 2,000 mentally ill patients as a result of its announcement to cancel its contract with the mental health care facility, which is Life Acid Remains Waverley. Further knows that the contract is apparently cancelled due to unaffordability. Yet it is the same Gauteng department that is subsidizing e-tolls, which has been rejected by the people of Gauteng, costing billions of rands. But it does not have funds to provide health care to 2,000 mentally ill patients. Council must further know that the blatant disregard of this ANC government to provide decent health care for the poor masses of our country. This ANC government has made it painfully clear that those government programs that provide services to the poverty-stricken in our country must be prioritized for budget cuts, and those funds are redirected to government programs such as e-tolls. We call on Council to denounce such actions against our poor and vulnerable. We call on the people of South Africa to reject the ever-promising, never-delivering ANC government at the voting polls. The EFF is our last hope for jobs and service delivery. I so move.
Is there any objection to the motion? Therefore, the motion is not carried.
Just on a point of order, Honourable Chairperson, I missed the last, but did the previous speaker say that the DA is the last hope for job creation in South Africa?
No, that's not a point of order. No, it's not a point of order. I'm not carrying it. Honourable Shibagwan? Honourable Thandi Shibagwan?
Mpambos Bugana, Chairperson. Dumdanekazi. On behalf of the Democratic Alliance, I hereby wish to move without notice that the escalating number of deaths on South African roads is a cause for concern, especially during the respective South African public school recess periods such as the upcoming Easter weekend. In the light of this, Chairperson, the House calls on the Minister of Transport to present the department's plan and strategy to this House on how they plan to combat drunk and reckless driving during the Easter weekend. I so move, Chairperson.
Is there any objection to the motion? Is there an objection? Therefore, the motion is not carried. Any other member? Honorable Julius?
Thank you, Chair. On behalf of the Democratic Alliance, I hereby move without notice that the DA is pleased that the Supreme Court of Appeal has this morning dismissed the state's request to appeal the Omar al-Bashir matter that caused international embarrassment when our government facilitated this fleeing of the jurisdiction despite domestic and international law prohibiting them from doing so. I so move.
Is there any objection to the motion? Therefore, the motion is not carried. Any other member? That brings us then to the end of motion. The Secretary will read the first order of the day.
Consideration of report of the Select Committee on Social Services, draft regulation submitted on 4 June 2015 in terms of section 43 subsection 4A of the Prevention and Combating of Trafficking in Persons Act 2013, number 7 of 2013, and the directives submitted to Parliament on 4 June 2015 in terms of section 44 subsection 7A of the Prevention and Combating of Trafficking in Persons Act 2013, number 7 of 2013.
Honorable Dlamini.
Thank you very much, Honorable Chair. My greetings to the Minister, MECs from different provinces, especially my MEC from my beautiful province, Honorable Kolwane, special delegates, honorable members. Honorable Chair, there is no one person who can take EFF seriously as the last hope. Reason being that they don't take the business of the people serious. You can see he is only one in the house. The rest of them are not here. So no normal person will take them serious. Honorable Chair, in August 2013, President Jacob Zuma...
Honorable Member, on what point are you rising?
I don't know if you're allowing this personal attack on me as a member of the Economic Freedom Fighters.
Is that a point of order?
Yes, it's a point of order.
That point of
I'm
order
asking you, are you allowing this personal attack on me?
The point of order is not carried because of this matter for debate.
Okay.
Continue.
So let me inform her that other members are coming, they are on their way. They are not upset.
Can you take your seat?
They are just right outside.
Can you take your seat, Honorable Member?
No, thank you very much, Chair. Nobody would ever take people who are always late or absent in their meetings. In August 2013, President Jacob Zuma signed South African first comprehensive anti-trafficking law in Prevention and Combating of Trafficking in Persons Act. The new law provides for the fines of up to 100 million or $9 million US. However, the actual number of people trafficked is difficult to estimate, Honorable Chair. Reason being that there is a wide difference from different sources. The lack of centralized database of human trafficking and legislative shortcomings that hindered prosecution were the main reasons why a true reflection of the situation was difficult to establish. It is difficult to get actual statistics, but it is clear, Chair, that human trafficking does take place. Chairperson, we also know that there is an agreement on the reasons why people are being trafficked. Most victims of trafficking are used for forced labor, forced marriages, sexual exploitation, organs trafficking, mutilation, and drugs mules. It is against this background, Honorable Chair, that the Select Committee on Social Services invited the Department of Social Development to present on the draft regulations. It should be noted, however, that trafficking regulations were tabled in Parliament on the 4th of June 2015, and it was automatically deemed approved by Parliament because, Honorable Chair, there were no comments or feedback from Parliament, and it is assumed approved if after 30 days there is no such. Consequently, the regulations were deemed to be already in force, and the department is required to act on them. On that note, Honorable Chair, the presentation to the Committee Social Services was to provide progress made so far in terms of the implementation by the department. This, Honorable Chair, was done on the 16th of February 2016. South Africa is a signatory to a number of international agreements, and therefore it must pass and abide by these international legislative frameworks. The draft regulation gives effect to the United Nations Protocol aiming to prevent, suppress, and punish human trafficking, especially of women and children. It is also planned to supplement the UN Convention against transnational organized crime. According to the Department of Social Development, this act was the first piece of legislation that addresses the need of the victims of trafficking in person. It addresses victims' empowerment programs and set up measures to protect and serve victims in dedicated facilities. In this regard, the Department of Social Development has developed a policy framework called Quality Trafficking Persons Framework in line with the Prevention and Combating of Trafficking in Persons Act No. 7 of 2013. The policy framework seeks to regulate the procedures with which social services or social providers, organizations, and institutions need to comply. It goes further to address the broad compliance and non-compliance issues of management in the organizations. Department of Social Services provided a comprehensive briefing on the regulations in terms of prevention and combating of trafficking, as well as progress. Members of the Select Committee, after the presentation by the department, raised a number of clarity-seeking questions and comments with the Department of Social Development. These includes, amongst others, skills development. What kind of skills development provided to victims of trafficking to cope with the trauma associated with being a victim of human trafficking? How the department monitors the impact of its programs in making in communities. Issues such as community involvement on issues around human trafficking was one important issue, the community involvement. Therefore, what is it that the social development is doing to ensure that communities are well informed of their roles in addressing human trafficking? Members also raised issues of children being killed for body parts because some believed that this would bring wealth to them. An example was made: about 200 people were allegedly trafficked in Engobo in a form of a church, education, and work. The department stated that provincial interventions were underway by the provincial government in the Eastern Cape, But members also wanted to know the role of the national department. What are they doing to support the province in terms of that? Also, the Department of Social Development was requested to respond on taking note of issues around mutilated human trafficking in the Eastern Cape and Limpopo. This, Honorable Chair, it was because in the report, Limpopo and Eastern Cape was not included. Therefore, members indicated that those two provinces must be also included. In terms of voting, Honorable Chair, it was highlighted that voting on the regulations was a formality or compliance matter because the 60 days for Parliament to comment had lapsed. All members of the Select Committee, Honorable Chair, agreed and supported the regulations, except, of course, Honorable Chair, Honorable Mateis, who abstained. And Honorable Chair, we're not surprised. Why? Because they reject everything. I'm sure they also reject the oxygen that they breathe. You don't know how, Chair, whether, is it because they...
On what point are you raising, Honourable Member?
Yeah, point of order, Chairperson. May you please ask Honourable Dlamini not to deviate from a speech and concentrate on the speech?
No, that's not a point of order, Honourable Member. Can you take a seat?
I think she's being wayward
No,
now.
that's not a point of order. Can you take a seat?
I think she's being wayward.
Honourable Member, can you take a seat?
I like it that every time she looks into
Honourable
the paper,
Member.
she thinks of EFF
Honourable
members.
Member, can you take your seat?
Thank you so much.
Yeah, because they are wasting people's time. Chairperson, we don't know whether she abstained because they are benefiting from trafficking, or is it because they participate, they themselves? I'm saying or because they participate or they themselves in the trafficking, or whether they just don't care about the victims to be protected. So we don't know, Honorable Chair, but the committee agreed, Honorable Chair. In conclusion, some of the committee members were not convinced that it was possible for the department to conclude due to the pace that it was taking in terms of the implementation. The committee felt that it would like to visit some of the facilities in different provinces where the victims are kept and look at the standard. We therefore, Honorable Chair, submit to the House for consideration. Thank you very much.
Thank you very much. That concludes the debate. I shall now put the question, and the question is that the report be agreed to. In accordance with Rule 71, I shall first allow provinces an opportunity to make a declaration of vote if they so wish. Is there any province that wishes to make a declaration of vote? Western Cape.
Thank you, Honorable Chairperson. Section 43, subsection 4A of the Prevention and Combating of Trafficking in Persons Act of 2013, Chairperson, states that the crime in its nature is hidden and does not lend itself to the normal identification by service providers' acts of mobilization. For us, this means exploitation, Chairperson. We, the Western Cape, Chairperson, wish to state it crystal clear that the fact that trafficking affects the poor, the desperate, the uneducated, the marginalized and unprotected, it is imperative that we raise awareness of the rights, lack of awareness of risk, absence or weakness of protective organization, household insecurity, inadequate legal protection, and survivor vulnerability. Currently, Chairperson, we do support the Prevention and Combating of Trafficking in Persons Act, which aims to deal with the issue at national level. However, as the Western Cape, we find it fit to increase victim support services, support and referral system on programs, public education initiatives, continuous research as spearheaded by the Child Protection in Social Development to implement strategies. Chairperson, South African statistics show that at least 193 People were trafficked in South Africa from Jan to December for unjust purposes, ranging from sexual exploitation to forced labor, forced marriages, at the expense of cultural practices such as ukutwala, which infringes on one's freedom of choice and one's freedom of association. This includes the mutilation of body parts with the misguided belief that one will become wealthy as a result of this, and for this, as the Western Cape citizens, we feel it's a cause for concern. Domestic servitude, chairperson, and forced recruitment of child soldiers is also underreported, and we urge the government to go an extra mile in investigating potential cases in order not to deny victims justice. This means more collaborative means of justice to South African citizens, and we could combat trafficking going this way. We believe enacting the implementation of comprehensive anti-trafficking legislation that is victim-centered will be just the beginning. Inkolo yezizwe, chairperson, yamanguni, ethi ngokufumana isibindi, ngokufumana inhliziyo yomuntu ze uthwale ngayo, ukuze utyebe ngamampunge lonto. Mawethu masiqine kumgomo wokuba wonke ubani unelungelo lokuphila ngokomgaqo-seko. Makube xhosa kubeyele, ndiyabulela, chairperson.
Thank you very much. Any other province? KZN.
Thank you, Chairperson. In terms of the ILO estimates, 20.9 million people around the world are victims of trafficking in humans or in persons. And these persons are trapped into forced labor and sexual exploitation. It is also estimated that this kind of business generates approximately 150 billion US dollars, benefiting those that are benefiting from this industry. Ibhizinisi lokuhweba ngabantu, ibhizinisi eliyihlazo. Kumele kuliwe nalo liqedwe nya ngawonke amandla omthetho nemitheshwana engabakhona engaba nomthelela uvikela isimpilo ikakhulukazi zabesifazane nezingane zamantombazane ezincane kanye nabesilisa abayizisulu zalabo abashishina ngalolu hlobo lokubhizinisa ngabantu. Uhlobo lolu lobugqila banamhlanje besithi sesadlula esikhathini sokudayiswa kwabantu babe izigqila, kodwa lolu hlobo lwebhizinisi lusho ukuthi abantu basagqilazekile namanje. Ngakho ke sikushayela izandla ukuthi uhulumeni oholwa ukhongolose uhlabele emgama wabona kufanele ukuthi akushawe imithetho eqinisekisa ukuthi abantu balelizwe laseningizimu neAfrika bavikelekile ethenini bahlukunyezwe ilabo ongqowankulu isikakhulukazi abahweba ngabantu behwebela amanye amazwe. Lokho ke kuyasikhathaza ukubona ukuthi bancane kakhulu abantu ababushwayo noma abagwetshwayo ngoba bebanjiwe ukuthi bayingxenye yaleli shishino. Ngakho ke sishayela ihlombe ukuthi ikomiti le-select committee yaka social services lihlanganile labona kufanele ukuthi asishicilele lemitheshwana ukuze sidedele iminyango kahulumeni ethintekayo kuba isebenze ivikele abantu. Asimangala ukuthi khona labo abamelene nalomsebenzi omkhulu kangaka ngoba iANC yodwa eyazabalezela ukuthi abantu bakhululeke. iANC yodwa enozwelo ngempilo zabantu. iANC yodwa futhi enohlelo lokuvikelwa kweimpilo zabantu. Abanye abazi ukuthi abathini. Ngiyabonga sihlalo.
Thank you very much. Is there any other province, Eastern Cape?
Thank you, Honorable Deputy Chairperson. The Eastern Cape welcome the regulations, and that it is anticipated that with the commencement of this regulation, South Africa will see significantly more cases of human trafficking identified and successfully prosecuted. Human trafficking is a serious crime in South Africa, and up until now, the prevalence of this issue could have been estimated. The crime, colloquially described as modern-day slavery, now has its severity reflected in our legislation, with sentences being as severe as life imprisonment or a fine up to 100 million. This crime has been affecting particularly women who are victims that are subjected to this in the form of domestic servitude, and males are forced to work in street vending, food servicing, begging, criminal activities. So we therefore welcome this particular regulation, because it is important that it will therefore serve as a protective structure to ensure victims of human trafficking are given care and that which they need from various government and non-government role players. So we welcome the regulations.
Thank you very much. Any other province? In the absence of any other province, we shall now proceed with the voting, and I shall do that by calling provinces in an alphabetical order. Eastern Cape?
Yes, we do accept the regulations.
Free State?
Free State supports, Chair.
Gauteng? KZN? KwaZulu-Natal?
Yes, we support.
Limpopo? Mpumalanga?
We support.
Northern Cape?
Northern Cape supports.
Northwest?
Bokone Buphiri Mayadu Mala.
Western Cape?
Saqhaza.
All 9 provinces voted in favor, therefore the report is agreed to in terms of Section 65 of the Constitution. The Secretary will read the second order of the day.
Consideration of report of the Select Committee on Petitions and Executive Undertakings, hearing of the Maluti-a-phofung petition held on 26 and 27 May 2015 at Parliament, and the inspection in loco conducted on 5 August 2015 at Maluti-a-phofung Municipality.
Honorable Tobejan.
Thank you, Chairperson, Deputy Chairperson of the National House of Provinces. Ministers, Deputy Ministers, MECs, honorable members, ladies and gentlemen, good afternoon. The report I'm about to present, Deputy Chairperson, is going to tell you about the petition received from Maluti-a-phofung Municipality. The petition was served to this Parliament by Mr. Sello and Mokoena Machele on behalf of the people of Botshabelo. They were then, on top of that, supported by Mrena Tsolo Mopedi, Mrena wako Sichabeng sa Phutadichaba, Bokamoso village. This petition, Chair, was served on behalf of plus minus 500 families. Families that were evicted through the court order by the municipality of Maluti-a-phofung local municipality. The petitioner's chairperson at no stage contested the content of the court order. but at all cost, they were talking about the violations of their human rights in the process of evicting them. Morena Mopedi and the petitioners informed the committee that they themselves were under the impression that the land in question belongs to them. It is in that context that Morena Mopedi throughout kept on allocating site for residential for the people he was leading them, up until the municipality informed them that the land belongs to the municipality, donated by Public Works to be used by the municipality. We are, of course, of the view that the communication between the municipality and the community is the cause of contention. The municipality could not have the energy and courage to engage the community. They spoke to them through the, the rush kind of. And the community, as you would know, Deputy Chairperson, are still bleeding from the previous apartheid law of forced removal. They were very skeptical. They wanted to have a leadership that would not hesitate to engage them, convince them in whatever reasons that causes them to be moved away from that particular piece of land. The community used the community, despite for residential, also to keep their stock life in that particular part of the province. And when they were removed, of course, there were things that ordinarily, if you look at our constitution under Chapter 2, they were not supposed to happen. You might have the right as a municipality to relocate people, to evict people, but at no stage you'll have the right not to take into the human rights of our people into consideration. In winter, under a very, ice environment, families composed of children, women, and elderlies were exposed to the coldness as their shacks, their houses were demolished at night in that particular difficult time. Of course, we as the Select Committee on Petitions and Executive Undertakings, continuously we have been saying, while we understand that the law should be followed to its logical conclusion, the Constitution of the Republic of South Africa should always be on the center of whoever has been given the responsibility to deal with issues of this nature. The area that they were relocated to, Deputy Chairperson, the area was not developed in terms of, service delivery expected for normal life. We are aware that ordinarily when you remove people from one place to another, their life should be better off than before you remove them into that particular area. They found themselves being dumped in an area that does not have not a single service that you may think of. No water, no roads, no infrastructures developed for them. And it was for that context that the committee unanimously, without party line, we agreed that we need to make sure that we are discouraging the kind of behavior that we have seen in Maluti-a-phofung when they removed people from where they were residing into a new place. We had an inspection in loco that informed us, and we came to the following conclusion, Chair, that the municipality moving forward should ensure that respect the law of this country. The Municipal Structural Act 117 of 1998 provided in section 81 that traditional leaders should be part of the municipality. And in the said municipality, traditional leaders are not part of that particular council. We have said again, Deputy Chair, that the municipality should see to it that it accommodate those families. In fact, it prioritize those families when it comes to, having its own, program of building houses. We also said municipality should accommodate evicted families in housing programs, of course, in the manner that will be fair and just. We were saying that because we know that municipality already have its own, program and priority of their own people. So hence we spoke about the fair and just. We said municipality should clearly ascertain and determine how many individuals were evicted from those particular villages we spoke of. The municipality to provide the committee with written submission on how it arrived at determining that only 39 houses were then evicted. We further said the very same municipality should provide the NCOP on a quarterly basis, Chair, a report of changing the lives of those people, because we cannot leave them as they are without being attended. Their life should be, improved. They must feel belonging to South Africa, the South Africa that is caring. We cannot allow our people, Chairperson, to continue thinking of the previous torturing system of apartheid. This democracy belongs to the people of South Africa, including those of Maluti-a-phofung. We are moving that this report be adopted by this August House. Thank you, Chairperson.
Thank you very much. That concludes the debate, and I shall now put the question, and the question is that the report be agreed to. In accordance with Rule 71, I shall first afford provinces an opportunity to make a declaration of vote if they so wish. Any province? In the absence of that, we shall then proceed with the voting. Eastern Cape?
Well, we support the proposition. Thank you.
Free State?
Chairperson, based on the recommendations made, Free State supports.
Gauteng?
Gauteng supports.
KZN?
KZN supports.
Limpopo? Mpumalanga? Northern Cape?
Northern Cape supports.
Northwest?
Northwest supports.
Western Cape?
Understand.
All 9 provinces voted in favor, therefore declared the report as agreed to in terms of Section 65 of the Constitution. The Secretary will read the third order of the day.
Consideration of report of the Select Committee on Petitions and Executive Undertakings, hearing of the Compensation for Occupation for Injuries and Diseases Act 1993, petition held on 6 May 2015 at Parliament.
Honorable Tobejan.
Thank you once more, Honorable Deputy Chairperson. Protocol observed. I'm not going to repeat myself in greeting you. Chairperson, the report I'm presenting to you is as a result of the petition received from Mr. Duduzela on behalf of 22 other disabled ex-miners. Mr. Wilson Duduzela is a disabled ex-miner from the province of KwaZulu-Natal, Honorable Deputy Chairperson. In this particular petition, Deputy Chairperson, Mr. Duduzela requested the intervention of the National Council of Provinces in the intervention to amend the Compensation for Occupational Injuries and Disease Act 130 of 1993, popularly known as COIDA, to ensure that the disabled compensation accord the disabled ex-miners and enable them to lead a quality and dignified life. Chairperson, in the presentation of Mr. Duduzela, he made mention that the said act continue to discriminate in dealing with cases affecting our people. And of course, the historical background of this particular implementation of the law was in a skewed way favoring predominantly the white citizen in the expenses of other races in South Africa. And he was then informing the committee that this discrimination, Chair, created a disparity that you will see in other ex-miners receiving compensations as they will be sitting home helpless, and others receive absolutely nothing. And the different way of those who receive differs from 1,000 to 4,000, while they're suffering from the same kind of disease, the same kind of challenges coming from the same source of, injury that they've received. It was encouraging, Deputy Chairperson, that the stakeholders in that regard, Department of Labor, agreed that indeed they do know of those particular challenges, and they are in the process of addressing that anomaly. They themselves acknowledge that the reason for the review of the said act is basically, amongst other, based on those challenges raised by Mr. Duduzela. It was not only the department, Chairperson, the Rand Merchandise Assurance, which is administered the funding of those, ex-miners, also supported that particular call of the amendment of the said particular act. The committee then agreed, of course, after the presentations by all the stakeholders, that the department should ensure the proposed amendment to COIDA are effected, seeing as COIDA has not been amended since 1993, and the amendments will greatly benefit those who are negatively impacted by that particular piece of legislation. The Department of Labor to constantly update the Select Committee, together with the Select Committee on Labor, on progress they are making in passing that particular piece of, amendments in that particular law. The Rand Merchant Assurance and Compensation Commission to examine ways in which disabled ex-miners can wholly and effectually benefited from the project intended to benefit them. Chair, this came as a result that there are projects that government have, put in trying to encourage these people to participate in improving their life but ultimate end, the goal of that particular, projects are not helping them that much. Hence, we are recommending that they must be in favor of, the interest of those former ex-miners and in particular disabled. The Rand Merchants Assurance Compensation Commission and the department to ensure those affected by COIDA gain a better understanding of COIDA, their rights and obligations, and the roles of various role players. It is necessary, Chair, because more often we do have pieces of legislation that, in our own understanding, seek to address the challenge of our people, but we don't communicate those, pieces of legislation effectively to our people. It is in that context that the Select Committee on Petitions and Executive Undertakings recommended that we should do better in educating our people about the pieces of legislation that intend to address the challenges that confronted themselves. We are moving for the adoption of this report, Deputy Chairperson. Thank you very much.
Thank you very much. That concludes the debate, and I shall now put the question, and the question is that the report be agreed to. In accordance with Rule 71, I shall first allow provinces an opportunity to make a declaration of vote if they so wish. Is there any province that wishes to make a declaration? In the absence of any, we shall then proceed with the voting. Eastern Cape? Free State?
Free State supports, Chair.
Gauteng?
Gauteng supports.
KwaZulu-Natal?
KZN supports.
Limpopo? Mpumalanga?
We do support.
Northern Cape?
Northern Cape supports.
Northwest?
Northwest supports.
Western Cape?
Western Cape supports, Chairperson.
All 9 provinces voted in favor, therefore to declare the report as agreed to in terms of Section 65 of the Constitution. Secretary will read the 4th order of the day.
Consideration of report of the Select Committee on Cooperative Governance and Traditional Affairs, notice of intervention issued in terms of Section 139(1)(b) of the Constitution in Umkhanyakude District Municipality, dated 23 February 2016.
Honorable Mark.
Thank you very much, Honorable Chair. Special greetings to everyone present here, the Minister, MECs present, honorable members. Chair, thank you very much. I'm going to present on behalf of the Select Committee the report of Umkhanyakude District Municipality. Chair, on the 7th of October 2015, the PEC of KwaZulu-Natal Province resolved to intervene in Umkhanyakude District Municipality in terms of Section 139, subsection 1B of the Constitution. The basis for invoking Section 139, subsection 1B of the Constitution was due to persistent governance and institutional matters, financial viability and management, and basic service delivery challenges. In July and August 2015, the Department of COIDA and Provincial Treasury deployed a support team comprising of financial, technical, and governance experts at the municipality in line with Section 154, subsection 1 of the Constitution. However, it became apparent that the support team was unlikely to succeed in turning around the municipality unless the intervention was elevated to Section 139 of the Constitution. In terms of Section 139, subsection 2B, Roman alphabet 1 of Constitution, the Minister of COIDA approved the intervention. Perhaps I must emphasize, sharing the same views as the Select Committee with the Minister doesn't mean rubber stamping. It means after looking at substantive evidence before us, constitutionality, and the matters of procedure, we came to a standpoint to say we support intervention, not to rubber stamp. In terms, Chair, of Section 139, subsection 2B, Roman alphabet 1, it's on record that the Minister has already approved it. Us as the committee, we looked at the following. The only structures operating optimally in the municipality is the council and the executive committee. The rest of the structures, in particular the portfolio committees and the public accounts committee, have not met as regularly as they were supposed to. In terms of productivity, all indications were that these structures have failed to exercise effective political oversight over management. In the previous years, the municipality has hired and absorbed staff in non-core functions, hence it was difficult for the municipality to right-size without retrenching employees. This was so because while the organogram was bloated, the municipality did have adequate personnel in core functions, particularly didn't have adequate personnel in core functions, particularly in water and sanitation. The provincial treasury found both the operational and capital budget of the municipality to be funded or in deficit of almost 117 million. On the 26th of August 2015, the municipality was instructed by the provincial treasury to revise the budget and prepare a funded budget in line with Section 18 of the Municipal Finance Management Act, and to table an adjustment budget in terms of Section 28 of the Municipal Finance Management Act. Due to the fact that in July 2015, management used part of the 2015-16 equitable share allocation to offset 2014-15 creditors, eliminating the budget deficit proved to be difficult. By the 25th of September 2015, the Municipal Council again considered and approved an adjustment budget which remained unfunded to the tune of 57 million. Further, the municipality adopted cost-cutting measures at the beginning of 2015. This didn't yield any result due to lack of commitment by senior managers and political leadership to implement the measures. In March 2015, the Department of COIDA suggested to the municipality that these cost curtailment measures be reviewed in line with measures used by the provincial treasury. The principle was accepted, however, both management and political leadership again failed to implement the measures. There was simply no political will to turn around the finances of the municipality. The municipality consistently failed to produce an updated audit opinion to track the progress made in addressing the issues raised by the Auditor General in 2013-14 management letter and audit report. As a result, the Department of COIDA couldn't make an objective assessment to determine progress in resolving the issues raised in the AG's report. At a meeting held on the 8th of September 2015 between the municipality, COIDA, provincial treasury, and all other local municipalities, there was a deluge of frustration from local municipalities concerning the poor performance of Umkhanyakude District Municipality regarding the delivery of water and sanitation services, as well as the neglect of the existing water and sanitation infrastructure. The municipality underspent on its 2014-15 MIC allocation, resulting in 40 million of the original allocation of 206 million being stopped. In terms of the Section 19 of the Division of Revenue Act of 2014, of the reduced 2014-15 allocation of 166 million, the municipality only managed to spend only 118.5 million, of which is 71.3%. The municipality admitted that this was due to poor performance of contractors, project reprioritized, and lack of project management unit capacity, which are indicators of planning and management deficiencies. An administrator was appointed as ministerial rep at Umkhanyakude District Municipality, tasked with the preparation and implementation of the recovery plan. The PEC requested the Provincial Treasury, COIDA, and the Department of Water Affairs and Sanitation to solicit 40 million for the operations and maintenance at the district as a matter of urgency. The Provincial Treasurer made available 33 million. Further, the PEC supported the proposal made by the Provincial Planning Commission around engaging Umkhanyakude Water Board to assist with the turnaround program to ensure that people get water urgently. As a select committee, we condemn the utilization of conditional grant funds to meet operational expenditure of the municipality, which is in contravention of the Section 17 of the Division of Revenue Act. Equally, the internal control environment of the municipality remained weak. The management persistently failed to implement policies and procedures, resulting to the ballooning of unauthorized, irregular, wasteful, and fruitless expenditure. During his State of Nation address this year, the President mentioned that drought has affected 5 provinces and that government was providing relief to affected communities. The Department of Water and Sanitation has handed over water tankers to some of the municipalities affected by the drought in KwaZulu-Natal. In particular, Umkhanyakude was one of the municipalities that was assisted. The water tankers, which came as per direction from the Water and Sanitation Minister, Menovula Mkonyani, will go a long way towards ensuring that local municipalities serve communities better. As a result, 5 trucks were handed over to Umkhanyakude. The drought has put a strain on already stressed water resources in the district. Although drought is a natural phenomenon which cannot be prevented, however, the district as a water service authority, should mitigate its economic and social impact on its people, taking into account that water is a scarce resource in South Africa. Therefore, the key focus is on all stakeholders to mitigate the impact of drought on households in our communities. My apology. In respect of the district Back to Basic plan, it was observed that the municipality took long to adopt its plan. The assessment of the program in the municipalities at the end of June 2015 revealed that the municipality had to be recategorized from being challenged to a municipality requiring intervention. As a select committee, we therefore recommend the following, Chair, that the NCOP approves the intervention in Umkhanyakude District Municipality in terms of Section 139, subsection 1B, after considering substantive, procedural, and constitutionality, not necessarily rubber stamping. The Provincial Department of COIDA in KwaZulu-Natal province should have an agent bilateral with Umkhanyakude District Municipality to address and manage the improper use and underspending of the conditional grant funding. A report in this regard should be forwarded to the NCOP within 14 days after the adoption of this report by NCOP. That the Select Committee on COIDA will conduct a follow-up visit to the district municipality to interact with all stakeholders in order to determine progress on intervention and the implementation of Back to Basic program in the district municipality. That the Provincial Department of COIDA in KwaZulu-Natal, together with SALGA in cooperation with local government SETA, should facilitate training and capacity building for municipal officials and councillors to further deepen their competencies and understanding of the oversight role, legal framework, management, and policies that govern the activities of the municipality. That the administrator should investigate and take corrective steps to fast-track the disciplinary measures against the municipal manager and chief finance officer as a matter of urgency. Lastly, that the KwaZulu-Natal MEC of COIDA should table quarterly progress report to the NCOP and the provincial legislature on the status of intervention in the municipality, including the intervention. I thank you, Chairperson.
Thank you very much. That concludes the debate. I shall now put the question, and the question is that the report be agreed to. But in accordance with Rule 71, I shall first allow provinces an opportunity to make a declaration of vote if they so wish. Is there any province that wishes to make a declaration? In the absence of any, then we shall proceed with the voting. Eastern Cape? Free State? Gauteng?
Gauteng supports.
KZN?
KZN supports.
Limpopo? Mpumalanga?
We do support.
Northern Cape?
The Northern Cape supports.
Northwest?
Northwest, Mpumalanga.
Western Cape? All 9 provinces voted in favor. I therefore declare the report is agreed to in terms of Section 65 of the Constitution. Honorable members, we now come to the subject for discussion as printed on the order paper. In doing so, let me welcome the Minister and invite the Minister to the podium.
Thank you very much, Chairperson. Chairperson, March the 15th today is World Consumer Rights Day. It is being celebrated as such since 1983, but its origins date back to 1962, when the late US President John F. Kennedy was regarded as having given the first substantive speech on consumer rights. World Consumer Rights Day is organized and mobilized by Consumers International, which is a world federation of consumer groups and serves as an independent and authoritative global voice for consumer institutions. This organization was founded in 1960. It has 220 member organizations in 115 countries around the world, and South Africa is represented on this body through the National Consumer Commission. The main aim of World Consumer Day is to mobilize communities in support of the strengthening of consumer rights. The United Nations Guidelines for Consumer Protection advises developing countries in particular that consumers in these areas often face huge imbalances in economic power, in terms of educational levels, and in terms of their bargaining ability. and that it also recommends, therefore, that developing countries in particular should take active steps to ensure that consumers have the right of access to non-hazardous products, as well as the right to just, equitable treatment and to sustainable economic and social development. The United Nations encourages governments to develop and maintain strong consumer protection policy, taking into account its guidelines as well as national conditions. Chairperson, in South Africa, during the years of colonialism and apartheid, recognition of consumer rights was very weak, as was indeed recognition of overall human rights, particularly for people of color in this country. Bearing that in mind, this constitution adopted in 1996 actually was one of the first important statements after our democracy, Section 41 of which, read together with Schedule 4, identified the protection of consumer rights as an area of concurrent jurisdiction. The national framework for consumer rights in this country really dates back to two pieces of legislation. The first of these is the National Credit Act of 2005. It's been amended in several occasions since then. First came into force in 2005. And the other one is the Consumer Protection Act of 2008. Between these two acts, they have created three important bodies which exist at national level. These are, first of all, the National Credit Regulator, the National Consumer Commission, and the National Consumer Tribunal. In addition to that, consumer protection is provided in a number of other pieces of legislation, competition law, various pieces of financial regulation, environmental management policy, things like the Home Mortgage Disclosure Act, reviews of through the Estate Agency Affairs Act, Promotion of Access to Information Act, Promotion of Equality, and the Prevention of Unfair Discrimination, and so on. Provincial consumer protection authorities exist in all the provinces and in fact predated the national institutions. Provincial consumer courts have jurisdiction over complaints of unfair business practices in respect of relevant legislation. A consumer court can declare business practice unfair and in contravention of provincial legislation. Chairperson, the objectives of the consumer policy framework of this administration and of its predecessors are to promote a fair, efficient, and transparent marketplace for consumers and business, to provide a consistent, predictable, and effective regulatory framework that fosters consumer confidence but also recognizes the developmental imperatives of the South African economy, that provides access to effective redress for consumers as well as economic citizens, that recognizes and supports the roles of activist and confident consumers in promoting a competitive economy, in promoting customer responsiveness in the private and public sector, and in harmonizing our consumer protection framework with international best practice in the best jurisdictions in the world. The Consumer Protection Act has been described as a revolutionary act designed to change the way in which people do business in South Africa. And some have called this a ground-breaking piece of legislation. While the Consumer Protection Act is mainly known for the protection it affords to ordinary consumers, it may not be widely known that small businesses with an annual turnover and asset value of 2 million rand and less are also protected in the same way as individual consumers. In other words, the vast majority of informal traders are regarded as consumers when they purchase goods from suppliers that they intend to on-sell to ordinary consumers, and they're regarded as suppliers when they sell goods to consumers. So in their transactions with their suppliers, they are protected under the provisions of the Consumer Protection Act. The Consumer Commission has established that what consumers want is quick, cost-effective remedies when it comes to disputes with suppliers. And in order to try to do this, the National Consumer Commission has been focusing on the establishment of various industry and sector onboard schemes to provide quick and effective redress. This has been happening over the last few years, And just to give an example, I've recently approved the motor industry scheme, the motor industry ombud, as well as the consumer goods and services ombud scheme. Both of these schemes provide quick alternative dispute mechanisms for consumers when issues arise. Ordinarily, when a dispute exists, the framework is such that the two parties are encouraged to resolve the disputes themselves, if not to go to the ombud, and then only thereafter does the National Consumer Commission intervene. But the National Consumer Commission will, in the course of time, also be looking at the effectiveness of these kind of ombud schemes and making sure that they do conform with the provisions of the Act. In addition to this, consumer safety is a matter of great concern. It's vitally important that consumers are supplied with reliable goods, and in fact, consumers have the right to be supplied with goods which correspond with the way in which they are presented to the consumers and which are safe for consumer health as well as for the environment. The National Consumer Commission is working closely with other bodies involved in this space, in particular the National Regulator of Compulsory Specifications, which sets compulsory minimum standards in this country, as well as with enforcement agencies. I want to just draw the attention of members of the House to one campaign which we've been highlighting in this regard, and that is the campaign on unsafe paraffin stoves. The basic requirement under the compulsory specifications is that paraffin stoves that are legally sold in South Africa, if they fall over, the flame is supposed to go out. The paraffin is not supposed to go all over the floor and cause fires. Unfortunately, there's a 30 Rand difference between the locally made stove which complies with those specifications and imported alternatives which do not. And we have found through our campaigns in places like Kayastans and in Tembisa, we have found that many, in fact most, of the residents in informal settlements, probably for reasons of the price difference, are using the imported substandard products. What is also of concern is that those fires caused by substandard paraffin stoves are often the major cause of fires in informal settlements, fires which cause huge damage to the property of the individuals concerned, cause serious injuries in a number of cases, and also absorb significant resources of municipalities and of government in general in terms of putting out fires and in terms of dealing with things like injuries, support for communities when they've lost all their property, and so on. We want to roll out this campaign much more urgently, and I would invite members of this House to work with us around this as we're seeking to build stronger partnerships so that we can root out these products and use the tools of the Consumer Protection Act in this regard. In addition to that, the National Consumer Commission has been involved in product recalls. It has recalled a number of products which are unsafe, including various motor products. It is also involved in enforcing compulsory labeling of products and so on. The National Credit Regulator is well known to members of this House, and I will remind members of why. But it is established in terms of the National Credit Act of 2008. The National Credit Act has also been described as a groundbreaking piece of legislation, and indeed on some occasions has been attributed to one of the reasons why South Africa was immune from the systemic financial crisis and toxic debt crisis which affected many financial institutions in 2008. The National Credit Act has sought to discourage credit providers from engaging in reckless lending by providing the ultimate sanction that reckless lending transactions can be declared null and void through a process in the courts. It has also made it an offence for credit providers to hold cards and PIN numbers of consumers. It prescribes maximum rates of interest and service charges, and in general terms seeks to ensure that credit providers are not allowed to prey recklessly on consumers of credit. However, of course, I think we know that this is a moving target, and we know that there are many non-compliant credit providers, not just small-scale businesses, but even larger businesses, and the credit regulator is involved in constant battles to try to uncover these and to refer them to the National Consumer Tribunal when uncovered. Why the National Credit Regulator is well known to members of this House is that members of the Select Committee in the previous term worked with the National Credit Regulator on an amnesty for adverse credit findings of people in credit bureaus. I can report to members of this House that that amnesty was a success and that by March 2014 there were no records of anybody in credit bureaus with adverse listings. Unfortunately, since then, the numbers of people that have suffered through adverse listings has gone up, and currently about 11.8% of credit active consumers have adverse findings in the credit bureaus of this country. And that raises a broader issue. The broader issue is that consumers in this country, as they struggle to make ends meet in the coming months, interest rates were recently increased, as we all know, food prices are expected to rise, we face a very difficult and bleak economic immediate future with high levels of unemployment and poverty in the country. And what this means, I think, is that we can expect that some credit providers will be tempted in such an environment to cut corners and to engage in shady practices among consumers. If we look at the figures right for now, they actually tell us quite a worrying story. We have, as of the 30th of September 2015, the total principal debt in this country was 1.63 trillion rand. In terms of the credit standing of consumers, 42.3% of the 23.45 million credit active consumers were classified as impaired, meaning that they were more than 3 months in arrears. In order to relieve the burden, the National Credit Regulator, through the new amendments and the regulations which have come through, is embarking on a series of new activities. They include the registration and regulation of small credit providers that previously fell outside the requirements, a registration of alternative dispute resolution agents and payment distribution agents. They're seeking to monitor compliance with collection and sale of prescribed debt. And most importantly, we are prescribing new affordability assessment regulations. Credit providers will have to make sure that the provision of the credit to consumers is within the affordability tolerance as prescribed in the regulations. Further consumer regulation, consumer education and awareness campaigns are also critically important. Both the work of the National Consumer Commission and the National Credit Regulator are assisted by the National Consumer Tribunal. This is an alternative dispute resolution system that actually offers low-cost, in fact, free access for consumers, and those consumers are able to approach the National Consumer Tribunal. Its work has been increasing. I see I'm out of time. I simply want to say in conclusion, I want to commend this House for organizing this debate. I look forward to the inputs from the members, including from a number of MECs who are here present, and I look forward to working more closely to enhance consumer protection in this country. Thank you very much.
Thank you very much. Honorable Samin.
Thank you very much, Chairperson. Abagabuyi. Sola Bagabuyi abantu be-EFF. There is not even one now in the House, Chairperson. It shows how much they don't care about our people, the majority of our people, the consumers, which we are debating about today. In fact, it's a payday today. Honorable Chair, I had forgotten that bayodla le mali abayiholile abangayisebenzeli. They don't come to meetings, but they don't forget about the payday. It's worse, Chairperson, because bathole an increment which they did not oppose like they usually do. It's an embarrassment, but I think our people can see what is EFF. not even one. They can see it's easy because you can easily identify them. You can't see not even one red in the house. Honorable Chair, my greetings still stands earlier. Today, Chairperson marks 33 years of the World Consumer Rights Day, as has been said earlier, which was established in 1983. Chairperson, I will not want to go back on the purpose, why, and what it does. What I will say is that we really are very much grateful to have a government that is led by the African National Congress, a government that cares about the consumers. Bantu labaning bagiti, labatsenga tindvo, kubo somabhizinisi, labanakelela nguhulumende we-African National Congress. Sithandza kuyibonga kakhulu inhlangano yebantu ngoba ukube ngilomunye uhulumende abengeka bacabangele. Honorable Chair, we also note that most people who were affected in the past are poor and vulnerable people, which forms a majority yabo are black people. So that is why ANC said it is one of the priorities that it will do in government to protect the consumers. Honorable Chair. Chairperson, the arena of consumer protection has lagged behind in terms of legislative enhancements that were required to prohibit such abuse and exploitation, which also statutorily acknowledge the rights of consumers. In addition, Honorable Chair, the legislative measures that were in place to address such issues were often fragmented and administered across the board and across sectors. This fragmentation led to uncertainty in a number of sectors, and the result was that often many consumers' protection issues were not effectively enforced. A number of these fragmented pieces of legislation, I'm referring to the past, Honorable Chair, were also outdated as it had not kept trends with the changing circumstances and experiences within our economy. One of the most important challenges that it created by the sets of fragmented legislation was the fact that it had not kept pace with changing constitutional environment that had been created by the advent of democracy. It means that it was not in line with our constitution. In order to address the fragmented legislation and unfair business transaction between business and consumers, the South African government, which is led by the African National Congress, promulgated laws to protect consumers in this regard. The Consumer Protection Act was introduced to radically overhaul the manner and form in which business is conducted within our country. The Act now formally entrenches which type of business conduct between consumers and business it is deemed acceptable. It was not the case before, Honorable Chair. Uma ngabe umthengisi wento athi ama-conditions ngilawa, uma ngabe bengumthengi before owathatha njengoba anjalo. But manje ugovernment ubeka tinto letishoyo ukuthi ngitiphi tinto letamukelekile uma ngabe kunokuthengiselana phakathi kwasomabhizinisi kanye nomuntu lothengayo, unlike before. Previously, this was not the case, and many types of conducts were often unfair, but as there was no legislation of these issues, certain questionable practices were often a common occurrence. This was often the disadvantage for the consumers, especially the poor and the vulnerable, as indicated, Honorable Chair. To date, the Act formally entrenches the rights and obligations of both the consumers and the business. I will want to mention them, Chair, but just to say that under each consumer right, there are a number of things that are covered by one, but I will just go through the rights as they are stipulated in the Act. The first one is the right to equality in the consumer market and protection against discriminatory practices. The second one, right to privacy. The third one is right to choose. The fourth one is right to disclosure of information. The fourth one, right to fair and responsible marketing. And the sixth one is right to fair and honest dealing. The seventh one is right to fair, just and reasonable terms and conditions. As you'll know, Honorable Chair, that the conditions, usually they were written in very small words and using jargon words which was difficult to understand. You will only be explained to them when you have a problem, but when you buy, they will not explain to you as a consumer. The right to fair value, good quality, and safety. And the last one, Chair, is right to accountability from the suppliers. The South African government has put in place, through the Consumer Protection Act, practical protection measures afforded to consumers. I will mention the few, Honorable Chair. I will not go through all of them. The direct marketing. Through direct marketing, consumers are often complaining about certain practices employed by direct marketing companies. For example, one of the major complaints from the consumers is that related to the invasion of space, privacy, that often occurred when a direct marketing company would approach a consumer. This approach often took place at a place and time which did not suit the consumer. The Act now addresses some of these main concerns. The Act now provides for the establishment of an exclusive register whereby a consumer can now register a so-called preemptive block against receiving any electronic communication. This means, Honorable Chair, I think we're all affected, especially as consumers, where you get a number of calls from the companies selling you this and that, whether you're in a meeting or not, whether you are sleeping or not, they will phone you, sending you SMSs, MMSs, without checking whether you want to be phoned or not, because under normal circumstances, Honorable Chair, you would know that I want to buy a phone and go to a shop. But what has been happening with these direct marketing companies, they will phone you anytime. Bantu bakithi ke nyalo banelungelo lokuthi bayoregister kulento labathi i-exclusive register. Kuleyo register leyo, uma ngabe udibhalise lapho, abanayo i-right ukukufonela. If they insist to call you, they can be penalized because of that. So bantu bakithi bafuna bafundziseke ngalawo malungelo lawo. Honorable Minister, we need to educate our people so that they can know about their rights. The unfair contract terms. This Act prescribes that a supplier may not enter into an agreement with a consumer that is patently one-sided, unreasonable, or unfair in order to assist both business and the consumer. The Act outlines a number of issues that will be considered to constitute unfair or unreasonable contract terms, as indicated earlier, that lo mthetho lokhona-ke uyasho ukuthi ngiyiphi contract le right leto favor umthengi okanye nomthengisi, kungabe ukuthi le contract ifavor kuphela lo muntu lothengisako. The Act also obligates suppliers to use clear and understandable language within contracts so as to ensure that consumers are not misled. The terms and conditions, as said earlier, very small and using jargon language which our people did not understand. The Act is now preventing that. It is saying, lulimi lolusetshenziswa kule contract kufanele kube lulimi loluto understandwa ngulo muntu lothengayo kanye nomthengisi. The strict liability. This issue is one of the issues that has led to the most debate around the issue of liability. Section 61 of the Act, a distributor, producer, or importer, or retailer can now, in certain instances, be held strictly liable for any harm or damages suffered by a consumer flowing from the use of a product. Meaning that uma ngabe mina nje ngahambe ngiyothenga into lebatsite yokugcobisa sikhumba ukuthi ngibe muhle ingishise because I was misled, I can then sue that company. That is what this act is saying. This is a drastic shift from the previous situation where a consumer was lumped with the onus on providing negligence on the part of the producer, meaning that before bokufuna ube nesiqiniseko kube nento loyiproducayo lesho ukuthi vele lento lena kube nebudlapha esayidini lomuntu othengisayo, but manje umthetho uyakuvikela ukuthi ungakhona ukuthi ubasuke ngeproduct loyisebenzisile. It is not worth that a consumer will need to approach a court to constitute any claim for damages based on the strict liability. Ngaya nasekhoto ke manje ngithi abangiside nangumuntu ngishisa isikhumba bengisi ngidenda muhle njengoba kubhaliwe laphana nyalo sengilomela isikhumba sami ikhotho ngeke wathi ukuthi ing-assiste kuloko. In terms of warranties, consumers are now able to return and claim funds for poor quality of goods because there is now an implied warranty of 6 months.
Honorable Member, can you summarize?
Meaning that if unenduleke quality engekho right, uyakhona ukuthi uyiclaim or uyibuyisele emuva. Siyabonga kakhulu ke Honorable Chair kuhulumende we-ANC ukuthi asendele lo mthetho lovikela abantu bakithi labahluphekile. Ngiyabonga.
Thank you very much, Honorable Engelbrecht. Can you continue the debate?
Mr. Chair, this Rainbow Nation has come a long way with many injustices having taken place in the past. Therefore, the important Bill of Rights and the Consumer Protection Act indicate how important the rights of consumers should be. World Consumer Rights Day, organized by Consumers International, have 8 basic internationally recognized consumer rights. Mr. Chair, I suggest we unpack them and see how interested this government really is in protecting our consumer rights. The right to be heard, where consumers' interests are represented in the making and execution of government policy. In Tshwane, a Class 1 ridge in the Groenkloof Reserve, one of the oldest in the country, is being earmarked for development without an EIA or public meetings being held. All questions are being ignored, and the city is turning a blind eye. We may ask, what has happened to the right of concerned residents to be heard? The right to be informed, where consumers need to be given facts to make an informed decision. The bus rapid transport system in Tshwane, a planned and approved Line 2B with a 2-lane car and 1 bus lane per direction, has suddenly been changed to a 1 car and 1 bus lane per direction without a traffic or economic impact assessment to back these changes. We may ask, what happened to the right of stakeholders and residents to be informed? The right to safety, where consumers need to be protected against production processes that are hazardous to their health. In Tshwane, Hammanskraal residents have been exposed to contaminated water with high levels of E. coli. What has happened to their right to be protected against a potential health disaster? The right to choose and to be able to select from a range of products and services. Residents of Tshwane have been forced to accept the illegally installed Pew prepaid electricity meters, in spite of having their own prepaid meters, and had no choice when these substandard so-called smart meters, which were in fact only prepaid meters, were forced on residents without any benefit to either the residents or the finances of the city, instead costing the ratepayer in excess of 8 million rand. What happened to their right of choice? The right to a healthy environment, to live and work in an environment that is non-threatening to the well-being of present and future generations. Farmers and farm workers in the area surrounding the Rooiwal water waste treatment works are working where they cannot even breathe without using a mask due to the horrific smell. Here, millions of flies lie their eggs in the raw sewage overflowing onto agricultural land. Once valuable agricultural land has been destroyed, crops lost, and animals are dying. What happened to their right to a healthy environment? The right to redress. Residents of Hammanskraal have patiently been waiting for delivery of ANC promises 21 years after being promised basic services. And they still have to use wheelbarrows to access water over vast distances by foot. Where is their redress? The right to satisfaction of basic needs, having access to basic services like water and sanitation. The Rooiwal wastewater treatment works without regular manpower, maintenance, or chemicals.
Honorable Engelbrecht, just hold it. On what point are you raising, Honorable Member?
I am raising on a point of relevance to the topic that is being debated. Is the member relevant to the topic? Are we not debating consumer rights?
No. Take your seat, take your seat. No, that's not, I'm not going to carry that order. It's a debate, and let's allow the debate to continue. Continue, Honorable Member. On what point are you raising, Honorable Faber?
Chairperson, I would just like to remind the House that it is the Honourable Member's maiden speech, and I also like us as House to respect that. Thank you.
No, I have established that to a point where I'm going to allocate an extra minute.
Thank you, Mr. Chair. The Rooiwal wastewater treatment works, thank you for the consumer rights, thank you. The Rooiwal water waste treatment works, without regular manpower, maintenance, or chemicals, has resulted in raw sewage spilling into the once mighty Arpies River, destroying the surrounding agricultural land, contaminating the water provided to residents and farmers in that whole Hammanskraal area. What has happened to their basic right to clean, healthy water and sanitation? The right to consumer education, to inform consumers to make informed choices about goods and services. The residents in the north of Tshwane should be informed that the water they are drinking is a serious health risk, especially to children and the elderly, with daily accounts of hospitalized patients. What has happened to their right to know? The few examples cited above clearly indicate that the different ANC-led spheres of government are not interested in protecting the rights of consumers. Instead, where the DA governs, change is really taking place, and the above consumer principles are being applied as fast, effectively, and efficiently as possible. And where the DA is working, we work hard to build one nation with one future built on freedom, fairness, and opportunity for all. I thank you.
Thank you very much. May I call on MEC Sommer?
Thank you very much, Deputy Chair, honorable members, the Minister, my colleagues, MECs from various provinces. Yes, indeed, the right to know has been entrenched in the Constitution of this Republic of South Africa because of the struggles waged by the African National Congress, which has made it a point that the people of South Africa are indeed entitled to all the rights enshrined in the Constitution. It is our own that would let them know, inclusive of the Member of Parliament, the Member Engelbrecht, who has just indicated in this House that she indeed knows what sort of dangers are faced by those people who live in the area of Tshwane. That right is the right exposed to the people equally so, not because as a right which is only exclusively to her right. It is the African National Congress who had made it a point that in our time, to govern this land, we must ensure that those who consume appropriately, protected appropriately, and they know the value of that right. It is indeed the expression of the people of the country, inclusive of those who are occupying these houses, that in their name we protect them in the right that they deserve. So in this house, we know the dangers because the law, which is enshrined in the chapters, both of the Constitution and relevant legislations for the people to know and be protected for all the times. I am representing the province of the Eastern Cape, yes, indeed, the home of the legends. Today, we join together to celebrate consumer rights across the globe. We do this mindful that all economic systems are based on delivering goods or services to consumers. In essence, they are the heartbeat of our own economy, and their activities drive economic growth and development. Nationally, there already exists a legislative framework outlined appropriately by the minister here for us to know this afternoon. It is the presence of that National Consumer Protection Act which ensures that consumers get the treatment that they deserve and are protected from exploitation. The National Consumer Protection Act prevents unfair business practices as well as exploitation of consumers. As outlined, this legislation creates an economic environment which supports and strengthens the culture of consumer rights and responsibilities. We say to the ANC, it was prudent indeed to ensure that this House of Parliament does ensure that our own people, those who consume services, are always protected. This law is founded on the prescripts of our Constitution, as consumer protection is a functional area listed in Schedule 4 of the Constitution of the Republic, as it is our responsibility to ensure that there is equality, there is exposure, there is transparency for all our people to be protected and be part of the South Africa which belongs to all who live in it. Consumer protection thus forms a necessary part of every citizen's socio-economic rights. To this effect, the values of dignity, equality, and freedom must underlie and inform any consumer protection policy and legislation. Consumers need to be aware of these laws because it is up to them to stand up for themselves, and it is important that they are cognizant of their rights and responsibilities. As the province of the Eastern Cape, through the Office of the Consumer Protector in the Department of Economic Development, Environmental Affairs and Tourism, we have a vision to empower and promote confidence in consumers to effectively invoke their rights, while understanding their responsibilities to enable all South Africans to make informed choices prior to purchasing goods or services. Honorable members, the income of households in the Eastern Cape has been on the incline. It has increased by approximately 60 billion rand over a period of 10 years. The Eastern Cape's disposable income, which is of a household income less taxes, was 136 billion rands in 2013, of which 133 billion was all spent. Most of the Eastern Cape's consumption and expenditure, out of that 39% is on the services, which is rent, transport, recreation, communication, and medical services. 35% of the province's consumption is on non-durable goods, while only 13% is spent on durable and semi-durable goods. 29.9 billion rand was spent on food, beverages, and tobacco, and only 2 billion rand on medical and pharmaceutical products. In the process of acquiring these necessities, consumers in our province are extremely vulnerable and can often be abused without consciously being aware. There is a serious need to ensure that consumers are made aware of their rights and become equipped to assert them. Educated consumers at times are more able to transact in a confident and meaningful way, thus leading to increased consumer confidence and responsible spending within the economy. This is not the case, unfortunately, in relation to those who are less fortunate in terms of accessing education. The Eastern Cape Office of the Consumer Protector was established in terms of the Eastern Cape Unfair Business Practices Act of 1998. Its key performance areas include education and awareness programs aligned to the trend analysis of consumer complaints as received. There are currently 6 educational programs, and in the first 3 quarters of the 2015-2016 financial year, 4,448 of those were participating in a way of ensuring that they are being reached in such educative instances. Another key performance area for the Office of the Consumer Protector is the receipt of consumer complaints with a mandate to facilitate the mediation and conciliation of any dispute arising between or among persons resident or carrying on business which is within the province of the Eastern Cape. During 2014-15 financial year, the Office of the Consumer Protector received 647 complaints from consumers. The Sarah Potman District Office received 46% of all complaints which have been received in the province. In the same period, 651 complaints were finalized by the Office of the Consumer Protector. In the finalization of consumer complaints, consumers received a saving in the 2014-2015 financial year, which is close to 178 million rands. During the first 3rd quarter of the 2015-2016 financial year, 429 complaints were received, whilst 413 of those have been resolved or finalized over the same time and period. The top 5 consumer-related complaints which were received by the office are as follows: on furniture and household appliances, 19%, motor vehicle-related complaints, 15%, financial services, 11%, cell phone-related complaints, 10%, debtors, whether in the judgments process or someone's negative credit ratings, were at the range of 6%. To improve service delivery imperatives in the province, a share call center was introduced during 2014, effectively creating a platform of taking the services of the Department of Economic Development, Environmental Affairs, and Tourism to the people in the province. Consumers are now able to lodge complaints telephonically, by telefax, by email, and can also seek advice at any one of the department's 6 district offices and provincial offices. To improve the quality of the service and to improve the turnaround time in the resolution of complaints, an electronic case management system has been introduced to ensure that all consumer protection officials are able to update incidents on a daily basis, and that feedback can be provided to a complainant at any stage. A further service delivery improvement initiative was the development of standard operating procedures for complaint support services, which sets out all procedures to be followed in the resolution of a complaint, with standardized timeframes and escalation process to ensure that services being delivered by the Office of the Consumer Protector are more effective, efficient, and consistent across the province. Honorable Chairperson, we have done all this because we believe consumers are important for our provincial economy, and their rights should thus be at the center of our provincial policy. The business community must recognize that business cannot exist without the support of consumers. The business community plays a pivotal role in job creation and economic growth in the province and have a key contribution to make in the socio-economic upliftment of communities. This is why we encourage business to ensure that they comply with consumer protection legislation to reaffirm the rights of consumers and to appreciate the valuable contribution that they make in the sustainability and growth of business. It is important, however, that consumers also play their part as well-informed and proactive consumers are critical factors within healthy markets and catalysts of competition. We're so proud that indeed South Africa has moved forward to take people at the center stage of sustaining its own economy, and consumers are a very critical component of such growth. Thank you very much.
Thank you very much, MEC. May I call on Honorable Tileni?
Hlekani mtshamo wa xitori. Hlekani. Namshawata hinkwenu. In South Africa today, thousands, if not millions, rights will forever remain an ideal if the economic freedom is not achieved, let alone consumer rights. Consumer rights have been failed by the ANC-led government. Together with white monopoly capital, all that is prioritized is profits at the expense of consumers. In most cases now, it is profit that has protection more than social economic welfare of consumers.
Just hold it, Honorable Tileni. Honorable, on what point are you raising?
Thank you, Deputy Chairperson. Can the Speaker reply my question?
Are you prepared to take a question, Honorable Tileni?
Ngizoyithatha ebhasini, angithi sihamba sonke.
Okay.
Ngizoyithatha ebhasini.
He's not prepared
I accept
to take a
it, but
question.
not here in the bus. Thank you. In most cases now, it is profit that has protection more than social economic welfare of consumers. Institutions such as the Competition Commission and National Credit Regulators are either not fully capacitated, instead they are doing half a job, or are influenced by profit and capture, which lead to decisions that do not have the interest of consumers, but greedy capitalists. At the end, consumers are left for their own devices. It is only those who have access and resources as consumers that will have their rights protected. Today, banks that are supposed to safeguard and keep their consumers' money safe, but the very same banks allow for illegal and unauthorized debit orders. And when consumers make inquiries, firstly, they are charged and then left to solve these problems on their own. This, in addition, lead to exorbitant bank charges that cannot be justified. Today, insurance companies are out to find every reason not to pay claims. Instead, consumers are sent from pillar to post. Today, phone companies like Vodacom and MTN do as they wish, even when evidence shows that South Africa is one of the most expensive countries to make a phone call or receive a message. Even the government goes around signing agreements that will bring products that are questionable. Indeed, if we want to advance protecting social and economic welfare of consumers' rights. It is time we must start listening to the people. We must start capacitating regulatory institutions for them to do their work in full capacity. We must introduce a strong penalty regime to discourage any attempt to undermine consumers' rights. Until such time, consumers are simply on their own and without any protection from government.
Thank you very much, Honorable Member. Honorable Tombel, can you continue the debate?
Thank you, Honorable Deputy Chair, Honorable Minister, Honorable Members. I rise to address on behalf of the Premier of the Province of KwaZulu-Natal, who could not make it to the sitting today. Honorable Chair, this year's Consumer Rights Day takes place amid economic crisis with millions of our people feeling a great sense of uncertainty regarding what tomorrow holds. A growing number of forecasts have revealed that food prices might rise sharply in coming months. As a province, we are mindful of potential abuse the consumers could find themselves during these trying economic times. Over the next few months, we are therefore going to ensure that we up the stakes to keep consumers vigilant and knowledgeable about their rights and obligations. The need to protect consumers arises from the imbalanced relationship between the consumers and the suppliers. It is evident that suppliers of products, goods, or services are in a dominant position. The need to protect consumers is also based on the fact that consumers may have the necessary information to exercise their choices, but factors such as the level of literacy and level of affordability may hinder consumers to make informed choices. It is worth noting that consumer protection does not only concern dealing with consumers and suppliers, but also with products and services acquired by the consumer, the quality, the standard, the safety, the ingredients, and the effects thereof of consuming the good or services acquired. The issue of quality is extremely important because with the rise in food price, many consumers may become victims of unsafe food products. We know that many households that live below poverty line often resort to buying cheap foodstuff. It is the duty of government to ensure that products selected by consumers are safe and of a certain standard and quality. Although the province of KwaZulu-Natal has made advances in the field of consumer protection, we acknowledge that the province is still at infant stage of the matter. It is for this reason that we are continuing with consumer protection campaigns as part of efforts aimed at creating awareness about consumer rights. We have reached more than 1.65 million citizens using different forms of communication that include interactive workshops. We have also reached more than 7 million consumers through the mainstream media as part of our campaigns. Our message is that as a consumer, you have a right to quality goods and services, the right to be protected against dishonest or misleading advertising or labeling. We are making our consumers aware that they have a right to choose products and services at competitive prices. Importantly, we have a fully fledged consumer complaint handling mechanism which ensures that complaints from consumers are investigated speedily. Last year alone, we had resolved more than 500 complaints received through the Consumer Protection Services Unit located in the Department of Economic Development, Tourism, and Environmental Affairs. We have also established a provincial consumer consultative forum which is aimed at strengthening relationship between consumers and suppliers. We have joined forces with a number of tech regulators, including the International Consumer Forum, Ombudsman for Banking Services, Estates Agency Affairs Board, and others to address the challenges faced by the consumers. Critically, as a province, we have enacted the KwaZulu-Natal Consumer Protection Act 2013, Act number 4 of 2013. The acts provide for the establishment of KwaZulu-Natal Office of Consumer Protector. We are placing a very high priority on the satisfaction of KZN consumers and want to improve their experience of KZN products and services. The object of the acts are, amongst others, to provide for a consistent, predictable, and effective regulatory framework of consumer complaints in the province, to provide for mechanisms to foster consumer confidence, to provide mechanisms for the protection of consumers in all areas of the province, while also aiming at promoting performance and competitiveness in the marketplace, to lay a solid foundation for leveling the economic playing field between the historical vulnerability of consumers and the power and influence of business, to promote and advance the social economic welfare of consumers in the province, and to provide for an accessible, consistent, harmonious, effective, and system of redress. Honorable members, as a province, we are committed to implementing programs and strategies to increase consumer confidence in the business environment and in the legislative framework aimed at protecting consumer rights. We are fully aware that we are becoming a gateway to Africa and the world because of our ports. Because of this integration with the economies of the world, the province is servicing the needs of millions of consumers locally and globally. We want all our consumers to be happy. We'll continue to place a high priority on the protection of KZN consumer and the global consumer of KZN products and services. In conclusion, I want to reflect once again on the economic crisis we are facing as a country and consumer issues arising out from the financial crisis. That as a province, honorable members will recall that when we started the previous term of office in 2009, the whole world experienced recession. The financial crisis brought out quite a number of consumer issues to the forefront. Prior to the crisis, consumer demand was high the world over, including the US. Consumer spending and consumption was high. Financial institutions supported consumer appetite with the wide usage of financial instruments, including credit cards and lending the area of subprime mortgages. The crisis saw consumers hit on a number of fronts. This included the effect of massive job loss in some countries, mortgage rates being reset, lending standard and criteria tightened, which saw large numbers of people losing their homes and other assets. As we celebrate Consumer Rights Day, we need to reflect on these issues and ensure that measures are put in place to protect our consumers from the negative consequences and the economic meltdown we're experiencing. I thank you, Chair. Thanks.
Thank you very much, Honourable Member. I call Honourable Kaila to continue the debate. Yes, Honourable Kaila.
Honorable Deputy Chairperson, consumers make up the largest economic group affected by almost every public and private economic decision. Individual consumers tend to be dispersed, while producers and traders are organized and powerful with greater access to information. Consumers are therefore more vulnerable to exploitation through deceptive advertising and selling, provision of fake products, and unethical trade practices. Such vulnerability creates poor value for money, undermines the welfare of consumers, and presents a risk to health and safety. Children, elderly people, disabled people, the poor, uneducated, and illiterate are particularly vulnerable. The introduction of the Consumer Protection Act in October 2010 provided a legal framework for consumers' rights to be protected. The Act clearly spells out the rights of consumers and the responsibilities of suppliers of goods and services. This is not just about following in the footsteps of the first world countries, but also is consistent with the United Nations guidelines on consumer protection. It is therefore of paramount importance that all business people and consumers are well equipped with the knowledge needed to comply with the provisions of the Consumer Protection Act. In this regard, we need, as public representatives, must make it part of our daily work to educate all citizens about their rights as consumers. Equally, business must be educated about their responsibility towards consumers. This civil education program should be supported by creation of strong and active consumer support forum, which will sustain and deepen their knowledge about their social and economic welfare as consumers. The EDM calls on the Office of the Consumer Protector to embark on an awareness campaign through local radios and print media.
This will empower the consumer, especially in the deep rural areas where most of them are unaware of their rights. Sithi ke mhlekazi, noko kuyafuneka bancedwe abantu abangaziyo, because phezilalini phezantsi emagqokolweni abawazi amalungelo abo. So ke siyacela ubana le protection committee make iyephe ebantwini, ingene kwi-radio ngesiXhosa not ngesingesi, ibaxelele because bayaqhathwa abantu bangaziyo. Thina noko sinenhlanzi siyabona bona baboni. Ikwa ngumsebenzi wethu ubana masekusoke siqhwaba sikhwaza uhaleluya okanye sikhwaza izilogans ze-ANC uba siyephe ebantwini sibafundise ubana akhona amalungelo enu umtshanam. Inkosi.
Honorable Manopule.
Thank you, Honorable Chair. I'd like to welcome you in this honorable house. We have missed you. I hope that you, in the long term, will find comfort. Let me greet Honorable Minister, MECs present here, NCOP members and special delegates. Ladies and gentlemen, together with the world, we celebrate the International Women's Rights Day today. We need to note the evolution of consumer rights in South Africa against the backdrop of the apartheid systematic and structural economy that was designed in a way of excluding rural people, which resulted them to be low income and poor consumers in the market sector. In redressing the inequitable terms of trade between the geopolitical and foster producer and consumer linkage, we needed to recognize the imperativeness to protect the interests of all consumers while ensuring accessibility, transparent and efficient redress for the consumers who are subjected to abuse and exploitation in the market. Perhaps before I proceed, Honorable Engelbrecht could not really go into the issues of the consumers. That does not, it says that she could not really highlight the realities of the scrupulous business practice of the business. In a way, it was defending the business people at the expense of the poor, while they want the voters of the poor. So to us, the vote of the poor black people is the transaction for them to be here in Parliament, to ensure that they have a voice, they have the stage, they have a platform to defend the alleged white business people who are their members also in their constituency. Consumers protection legislation are critical catalyst process towards redressing discriminatory laws of the past, which resulted in the high level of poverty, illiteracy, other forms of social and economic inequality. Furthermore, the legislations were employed to stop unfair, deceptive, and fraudulent business practice, notwithstanding vulnerability of the illiterate people. We had to note that the fact that they were exposed to unethical business practice after being excluded in economy activity of the country as opposed to the past regime. We know the various progressive pieces of powerful legislation in place to protect consumers under the ANC-led government, which are, the minister have highlighted them: Consumer Protection Right of 2008, National Credit Act 2005, and National Credit Regulator. The National Consumer Commission intended to protect the interests of all consumers, promote and provide for consumer education, including education concerning social and economic effects of the consumer choices, For long, the rural people has been in the periphery of the economy. However, we need to ask questions to what extent does this legislation benefit the rural people? Do they enjoy such benefits and the output of this legislation? Do the rural women in Khasikhonyani, Khasihunel in Vake 8 in the Northern Cape enjoys those benefits? Do the rural mine workers who continuously take expensive cell phone contracts without being told that their phones do not have insurance benefit? Perhaps the NCR, which is National Credit Regulator, and National Consumer Commission need to work closely together to entrench consumer rights and ensure that consumers across the country, especially most vulnerable, the workers and the poor, elderly, the rural and uneducated, have all protection that laws allows them to be protected when they borrow or they buy on credit. In case that in Khasikhonyani, in JTG, Moring Ntate Utusitse Moelani, o dulang ko Makhojane, ko Kurumane, ko Kapabokoni, o ileng a reka bete, televishini, ha itla ko gae, televishini e ngapegi, bete e na le mosima mo gare, e kobegi. Ha e busa, mongwe lebenkele a re, thoto e ke ya gago wa e tsaya a wa rata kgotsa ga o rate mare tšhelete ga nkitla o e bona. Ke tsengwe ya dilo tse di botlhoko tse e leng gore borre le bomme ba rona ba ba le ko magaeng ba ba sa itse go bala ba sa itse le go kwala ba e leng gore le ka tsatsi le la gompieno sentse ba tlhokofadiwa. So gape ke boeletsa ke gore ra itse ka sebaka se retrenchment e semeletse. Ba rona babereki ba rona ba di-mine ba ba tswang ko rural areas, ko Khasikhonyani, ko Gamagara, ko John Taolo Gaetsewe, ko Kurumane, ba retrenchiwa. Ba setse ba re ba kry-a megala go tswa ko mo ramabenkele, ba ba ra ba re he rrawe tlisa madi a kgotsa dithuto ra di tsaya. Se re ratla go itsisela gore minister, that is very important that the double blow of the retrenched mine workers are going to be subjected to by scrupulous business people in this current situation where they'll be retrenched. And because of these business people exploit the situation that they are not aware of the regulation and their protection that seeks to address and defend them. Therefore, we make a clarion call to the Consumer Credit Institution and National Consumer Commission under your leadership in the DTI to develop integrated, coherent activities for enforcement programs which will encapsulate a vigorous education program to consumers about the right and their responsibility in order to empower them against unethical business who wants to take advantage of illiterate rural people. This institution should emulate put into practice the words of the legend, Nelson Mandela, our former state president, when he says, I quote, "Education is a great engine for the development," close quote. It will go well with the rural people in Khasikhonyani and also where in the countries all the rural areas are seated. I would like to commend and applaud SABC2 program of Speak Out on the good work that they are doing by assisting our poor illiterate consumers to recover their monies and their goods and further educate them on their rights. Rural development and rural enterprise development, credit facilities and economic infrastructure program of government has unintended consequences where our people are exposed to all forms of marketing system, whereby the government wanted to redress the injustice of the past and address the market sector to the rural people of all forms of marketing. We know the emerging technology changes which affect trading methods and patterns. However, it comes to undesirable, exploitative and abusive business practice. The information and communications infrastructure which seeks to address accessibility by ensuring that internet broadband capacity provided broadband access improves, and it has been negated by unethical business behavior of scrupulous business by employing robocalls. Robocalls are telemarketing, which one the Honorable Dlamini was referring to, is the recorded sales calls or messages generated by illegal unless one has proven company that given a written permission to be called. And as well as auto dialers that can send out 1,000 phone calls to every minute at the incredible low cost to reach many people, which one that seeks to benefit only business people, that one seeks only to benefit business people. I see my time is up. To drive transformation of the state, we need developmental state that has capacity, technical, organizational capacity to mobilize the society and the state, that the people-centered and people-driven. Therefore, we call on that all of us together when we move South Africa forward, the NGOs, the civil society, to assist us to ensure that this credit act, this credit regulator, these credit commissions are implemented. Mabogo dinku atibana. Rotle re tla aga setšhaba se sa rona gone go protecta baagi ba rona ba ba le kwa dikobo dikhutshwane ba ba le ko magaeng ba itse gore ba na le ditoka ba na le melao ya gore e ba sireletsang.
Thank you.
Ya leboga modulasetilo.
Honorable Kaula.
Honorable House Chair, Honorable Minister, my colleagues, Honorable Somio, Honorable Ndombela, Honorable Kolwane, colleagues, South Africa has passed legislation to ensure protection of consumers against all forms of unfair treatment and or exploitation by providers. Amongst other things, consumers are entitled to accountability and disclosure of information by suppliers. The Act ensures that the product has not caused damages. The Act also provides a right to privacy, the right to honest dealing, the right to fair and responsible marketing, the right to fair value, good quality and safety, the right to fair, just and reasonable terms and conditions, and the right to consumer equality. The Act provides that if consumer rights are violated, consumers must seek compensation in court or through the National Consumer Tribunal. Whilst the equality of all South Africans is a right guaranteed in the Constitution, this is in fact a right that gets violated left, right, and center with very little or no consequence at all to the wrongdoers. How many times do you enter a shop and get service in the language of your choice, especially if you are African? How often do suppliers bother at all to market their products in languages that can be understood, especially by the African masses? How often do providers bother at all to draw contracts on paper in languages that can be understood by the African masses? These are issues that need to be addressed. The law itself is very discriminatory to the rural poor. If you have an issue with the provider, you have to go to court. Courts are urban and costly, or you have to go to the tribunal. The tribunal is located far away from the rural people. All important offices in South Africa are located in major cities where only the elite can be served and better protected. Challenges confronting poor and marginal households in South Africa include, like my colleague Manupulo was saying, borrowing from informal credit sources with high and unregulated interest rates. Even at the doorstep of government programs at pension pay points, this practice continues to harass the elderly and the vulnerable. The informal economy in South Africa is the order of the day, especially in townships and rural areas. The value of the quality of goods sourced from this economy is highly questionable, and who is there to ensure that the right to fair value, good quality, and safety is adhered to? The consequences of borrowing from informal credit services have disastrous effects to the needy, vulnerable communities. Some of these negative effects include selling household assets such as livestock, which affect the livelihood of the homestead of rural communities. Borrowing always comes with the cost of paying back the borrowed amount plus insurmountable proportions of crazy interests which have a negative effect and impact on poor households that are already struggling. Even with the class of our citizens who are literate, more often than not, people get taken for a ride by suppliers in various ways. The authenticity and credibility of information provided in the application forms is often intended to bypass a hurdle and a hindrance which would have been posed by the national credit regulator. These suppliers always have a way of pretending to be assisting with what to say and what not to say, as if it is to the benefit of the consumer. Such behavior is always a disaster to the future sustainable livelihood of the consumer in his or her ability to cope with the credit. In conclusion, on the one hand, the monitoring of the implementation of the Act is crucial, and on the other hand, education of communities on the rights of consumers is of utmost importance. So says Inkatha Freedom Party. I thank you, Chair.
Yabonga. Umphathisa welitiko letetimali eMpumalanga, umhlonishwa Kholwane.
House Chairperson, the Minister, members and my colleagues, MECs from other provinces who are here today, including the members of the media, Sanbonani. Honorable Chairperson, I bring fraternal and comrade greetings from Mpumalanga, the place of the rising sun, because as the sun rises, the hopes of South Africa's consumers rises too. Today, it marks almost a year after the unfortunate passing on of one of our freedom fighters, and the fighters was fighting against the injustices, comrade, the late Minister Collins Chabane. I rise to premise the theme of this debate on the Freedom Charter, which envisage a society where the people shall share in the wealth of this country. The clause finds expression also in our Constitution. The theme, as we have already know, advance our national resolve to protecting the social and economic welfare of our consumers, close quote. It's central to our Constitution, jurisprudence, which is supreme legal protection and enforcement of consumer rights underpinned by universal human rights. To this end, as a country, we have come a long way since 1994 to put in place economic policies which seeks to restructure the economy and eliminate inequitable distribution and acquisition of goods and services defined by the intersection of race, class, and gender. As we join the nations of the world in genuine partnership to advance consumer rights, we must first and foremost denounce the scourge of racism which continue to shape the commercial landscape in our motherland and across the globe. Chairperson, truth be told is that racism might be being removed from our statute books, but it harms historical scars and effects remain visible in our day-to-day social and commercial transactions. I am being reminded of a newly appointed official in the department I'm leading who saw an advert 3 minutes after it was posted for a flat to let, only to be told 1 minute later that the flat had already been booked. However, when a white colleague called inquiring about the flat, the same flat, 2 hours later, he was told to pay the deposit immediately to secure the flat. This is how racism can undermine consumer rights. As we celebrate international days like this, we must be guided by the fundamentals of the political economy too, amongst others, the racialized ownership and assets such as land and private equity. As we speak, ownership of equity listed on the Johannesburg Stock Exchange is skewed along racial lines. We remain with a a big task to continue to struggle, which seeks to equalize the distribution of income population groups, restructure state assets and procurement regime to support historical marginalized consumers. Chairperson, government's affirmative procurement policy framework, National Consumer Protection Act, and other related pieces of legislation form part of the ANC-led government's commitment to advance our national resolve of protecting the economic and social welfare of consumers. To this end, as Mpumalanga Province, we have and continue in our quest to create awareness on consumer rights by educating and empowering our people about their rights and responsibilities. This is evidenced by the number of consumer complaints we continue to receive. It is pleasing to note our success. In the last 2 financial years, we have investigated and resolved a total of 3,708 cases which were reported to us by consumers. In the process, the caring ANC-led government was able to recover about 12.8 million on behalf of the consumers. As the cherry on top, these successes were confirmed by the Auditor General after auditing the department's performance report and financial statements. The money we recovered on behalf of consumers went back to the pockets of the people in our province, thus protecting the social and economic welfare of consumers. Chairperson, we must work together to implement the United Sustainable Development Goal on consumer protection, which urges all countries to have implemented guidelines thereof by 2030. The Sustainable Development Goals are set to replace the Millennium Development Goals in due course. According to the United Nations, consumer rights are central to achieving sustainable development, given that they contribute to a fairer, safer, and healthier society and a more equitable and efficient economy. Once consumer rights are protected, they will contribute to the achievement of many other SDG goals, such as poverty eradication, equitable economic growth, improved health, water, and food. The recent march by the African National Congress to mobilize society against racism did not only underline the fragile social fabric, but it also highlighted racism as a stubborn barrier to the advancement of our national resolve to protect the social and economic welfare of consumers. United in action with the nations of the world, we will restructure global and cultural relations for the benefit of humanity. I therefore thank this august House for agreeing to debate the subject under consideration. The delay or avoiding of the national discussion on the theme before this House will not have served the cause of humanity. I thank you, Siyathokoza.
Thank you. Umhlonishwa Mthethwa.
House Chairperson, honorable members, it is of course my privilege to stand here before you during this month of human rights. It is of course Madiba who intoned that to deny people their human rights is to challenge their dignity. Accordingly, it has been the project of the African National Congress to ask of ourselves how to entrench and affirm the human rights of our people. Human rights, I'm talking about human rights. Yeah. In all the In
Order, members.
In a week or so, we will be commemorating the lives of those who took the bullet so that we may have the litany of human rights that we are proud of talking about today. For we must never forget that at the heart of Mzabalazo was a firm belief that all of should have the inalienable right to life, land, health, dignity, decent work, food, shelter, and security. According to Deputy President, the Honorable Cyril Ramaphosa recently asserted this call by highlighting the plight of sex workers. Speaking at the launch of the National Sex Work Sector Plan, the Deputy President announced that South African National Aid Council has partnered with Legal Aid SA to provide legal and paralegal support through a call center service to sex workers who are arrested. We are aware that the human rights of sex workers are often abused and undermined by those who are supposed to uphold them. The intervention of the Deputy President and other affected stakeholders will go a long way in curbing these abuses that are often rife in a sector that predominantly employs the working class. We will do well to remember that the Consumer Protection Act of 2008 was in response to the poor customer service that was meted out to the most working class among us. In this regard, I am certain that all of us sitting here can relate to an aunt or uncle who because of his or her average literacy skills was scammed of substantial amount of money by furniture retailers and lending institutions, either by charging an incredible amount of interest on procurement goods or inventing additional costs that are immaterial, if not unnecessary. Let me substantiate this claim by providing you with an example of our one customer who bought a washing machine in a hire purchase from one of the popular furniture shops. The advert.
Honorable Mtileni.
I just want to find out if the honorable member can take a question.
Okay. No, honorable members. Honorable Mteto, are you ready to take a question?
In the bus, I can take it.
In
no,
the bus.
Honorable Mtileni, it's saying it's not ready to take a question.
Oh, okay.
Continue, Honorable Mteto.
In the bus. The advert price for the machine was 6,000. However, in the end, the customer ended up paying machine the total of 18,000 rand. For honorable members, how is it possible that in the age of the National Consumer Act, retailers have the financial temerity to charge unsuspecting consumers up to 3 times the value of particular product? The furniture shops and
Honorable
others.
Mteto, Honorable Julius, why are you rising?
Thank you, House Chair. Just for relevance, with consumer rights and sex work, I don't know whose consumer rights are they.
Honorable Julius, take your seat. Continue, Honorable Mteto. Continue, Honorable Mteto.
One of these furniture shops was ordered in the last year by the National Credit Tribunal of to refund 44 million rand in fees that has been wrongfully charged to consumers. The tribunal was able to uncover that this particular retailer sold employment insurance to the unemployed as well as to pensioners. Of course, we understand that for business it is about the bottom line. We equally understand that the business is mercurial filled with uncertainty. Even so, these reasons are not sufficient enough to operate on predatory basis, stalking the elderly, vulnerable, and the unformed in order to appreciate a return on investment. We led a success of the National Credit Tribunal in the recuperation of about 200 million to nearly 200 consumers, as well as the number of compliance notices that have been issued. Even though we celebrate the success of the tribunal to hold the guilty to account, we are aware that they operate under limited resources. And it remains our design that agencies such as these bolstered sufficiently to be able to deal with the scourge of abuse perpetrators by retailers whose interest is not in the right of consumers that frequent them, but rather in their exploitation. The financial dispossession and led to mislead concepts such as cheap credit, when in truth we all know that credit is expensive, and the story of African Bank as well as 4 million over indebted consumers and 11 million consumers who have missed 3 or more payment attest to this. Not so long ago, the Honorable Minister Lindiwe Zulu facilitated a conversation with a constituency of retailers and small business in Mfuleni, a working class settlement that sprung 30 kilometers outside of the city of Cape Town. I wish to highlight the workshop for 2 reasons. The first being that these retailers and small business are mostly operating within the informal economic and perhaps experience firsthand both the challenges and the issues that consumers face. But far more importantly, this retinue of aspirational businessmen and women had just completed a course, Retail Conduct. One of these aspiring businesswomen, Mrs. Tozama Gwate, who runs a Shisanyama in town, to sum it up all in the following words, and I quote, we are happy to see that the minister is making a follow-up on what she discussed with us. The training shed light on many things such as customer care, how to handle our finances, and that we must keep our business clean, unquote. It is in this spirit that we urge business to conduct themselves with integrity and customer care that the likes of Mrs. Gwate alludes to, that those who sell goods and financial products to the poorest of the poor, the financially illiterate among us, the working and rural class, to not want to exploit and make a quick buck through unscrupulous business practices, however tempting it might be to do so. We commend the work of the National Consumer Protection Office, as well as the undertaken by the National Credit Tribunal in bringing to book those who wish to operate outside the framework of the law. In the year that we will be commemorating the 40th anniversary of June 16, we must undertake to ensure that umzabalazo for our human rights continue We must ensure that our people enjoy right, that they fought for, that they are able to walk into any shop and irrespective of their language they speak, the accents they have, the reading skill they may or may not have, that they will be treated with respect while being afforded a service that does not want to exploit, abuse, or overcharge. Our people deserve better. Sifuna ukusho lokhu.
Honorable Mtetwa, I'm afraid your time has expired. Tonishwa Isaac.
Honorable Chairperson, honorable members, fellow South Africans, the Minister came here and said he expected to hear some concrete speeches that would assist him when he leaves the House to go forward. But sadly, none of that, Honorable Minister, has still been forthcoming. But nevertheless, if one pays attention, perhaps you'd find pretty interesting what I have to say. So, it is common knowledge, Honourable Minister and fellow colleagues, that South Africa is currently facing the possibility of a ratings downgrade to junk status this very week, which makes today's debate even more significant. This will have a huge influence on our social reforms and quality of life. The rights of South African consumers have been influenced by various issues which have had a negative impact on the day-to-day lives of our fellow South Africans, which of course is having a huge influence on our social reforms and our quality of life as a whole. The increase in electricity tariffs granted by NERSA, a devastating drought, coupled with the rise in the fuel levy announced by the Minister of Finance in his budget speech some 2-3 weeks ago, will all further impact consumers already facing unemployment and job losses. Honourable Chairperson, it is during economic cycles as we are currently experiencing that credit granting to consumers remain a critical subject. South Africans are struggling, colleagues, causing our people and business to borrow even more money than they can afford to repay. And as in the words of my colleague, Honorable Faber, if it was not for the low oil price per barrel globally, South African consumers would be even more worse off in terms of inflation, with the cost of living that would have just escalated and gone through the roof. South Africans are exposed to an exorbitant amount of debt and are continuously exposed to borrowing from loan sharks, as we know it. Couple this with an exaggerated interest rate, and it becomes what we know as high-risk business. I sometimes wonder if members of the ANC, Honorable Dlamini, and the executive even know what certain foods actually cost. Based on the PAXA food basket, in February 2016, 4 loaves of brown bread would have cost a family 39.71 rand, as in February 2016. 2 heads of cabbage would have cost 27.95 rand, and 10 kilograms of potatoes would have cost them 70.63 rand. If a family consisted of just 3 adults and 2 children, this would mean that they would need to spend 3,062 rand per month just to meet their basic nutritional requirements. This on an income of 3,200 rand per month in terms of social grants for husband and wife. In 2015, Parliament approved amendments which were instituted by the National Credit Regulator in September 2015. The intention was, of course, as the Minister mentioned, to formalize the accessibility to credit by implementing more stringent rules and assessment criteria for loan applications. The South African people are being punished for being poor, for trying to provide for their families, and for not being able to find work in our current economic state. At the conference hosted by the Department of Trade and Industry in Sandton some 2 weeks ago, the National Credit Regulator, NCR Manager for Statistics, Ngwagu Mabeba, he of course painted a very bleak picture when he said that consumers owed some 1.63 trillion at the end of September 2015. Now I say to you, my colleagues, 22 years of democracy, and this current ANC government can no longer defend its track record. It's understandable that you get your blood pressure high, but apply your mind. Sadly, under the administration of the ANC, millions of South Africans are becoming poorer by the day. And you have fueled our unemployment rate to some 25% in this country. So this is why I say to you, colleagues, South Africa needs a government that does not punish its citizens that are poor and vulnerable. What we need, colleagues, friends, fellow South Africans, is we need a government that spends majority of its money on the poor. A DA government will ensure a competitive environment for job creation so that South Africans can provide for their food, potable water, access to basic quality education, and health for their families, which is all non-forthcoming. That caring government, Honorable Chairperson, you know as well as I do, is a DA government. Sadly, I've had some colleagues come up here, and it's sad to see that there was absolutely no substance in the speeches that were presented here, Honorable Minister. And perhaps you will guide and enlighten us when you do your rebuttal in a few minutes. I ask, Honorable Minister, why is the National Credit Regulator not being as proactive as it should be? The situation has worsened year by year. Please give us a concrete answer as to why there seems to be no apparent urgency by the NCR.
Honorable Isaac, sorry. Honorable Cook.
Chair, is the member prepared to take a question?
Honorable Isaac, are you prepared to take a question?
In the bus. That's the order of the day.
Can you take a seat?
Calm
He's not
down.
prepared to take a question.
So yes, you know, Honorable Minister, I just want to ask, we agree that we talk about talks. But, you know, sooner or later, we have to start seeing some visible improvement and regulation being physically implemented by the NCR if we are to make all of this functional. Honorable Kathy Dlamini, you had nothing much to say except that the ANC is the government of the day, so really no comment for you today. Honorable Monopoly, you talk of a higher level of poverty and unethical business practice. I agree, ma'am.
Honorable Isaac.
Sir.
Honorable Monopoly.
Chair, just want to find out to who it is Honorable Isaac referring to monopoly.
Honorable Isaac, you can't refer to her as Monopoly. It's Honorable Monopoly.
Sorry, did you say again?
You must refer to her as Honorable Monopoly, not as...
Honorable Monopoly.
Yes.
Okay.
As you conclude, Honorable Isaac...
And I conclude, colleagues, that yes, it is agreed that the situation continues to retrogress under the culture of corruption, which is continuously fueled by the ANC. My fellow South Africans, I thank you.
Thank you. Honorable Mtimunye.
Thank you, Honorable House Chair. You know, Honorable House Chair, seated there listening to members of the DA specifically, combined with Honorable Mtileng, I'm not sure whether to refer to them as strange bedfellows or opportunists of a special type. I make reference to this, Honorable House Chair, because to me, Honorable Engelbrecht chooses to have an interest of the peoples of Hammanskraal only in 2016 and not in 1986. What opportunism. Having said this, Honorable House Chair, you know the truth. The truth, only the truth will set you free. Having said this, Honorable House Chair, can I make reference? In his book, The Pedagogy of the Oppressed, Paulo Freire, a scholar of Marxist and Lenin, had this to say, and I quote, open quote, problem posing education as a humanist and a liberating praxis pose a fundamental that the people subjected to domination must fight for their emancipation. To that end, it enables teachers and students to become subjects of educational process by overcoming authoritarianism and alienating intellectualism. Students and teachers, in this case, I refer to monopoly capital versus a consumer. It also enabled people to overcome their false perceptions of reality. The world is no longer something to be described with deceptive words. Because the object of that transformation by men and women, which results in humanitarianism, close quotes. So here comes the ANC takes on the teachings of Paulo Freire, Honorable House Chair. South Africa's colonial experience and advancement by the colonial order of capitalist mode of production was based on the intersection of super exploitation and accumulation structured by production relations of power based on class, race, and gender. These social and biological features produced a political economy of exclusion and repression to create the socio-economic order of dependency on the colonial master. Apartheid, as a benefactor of colonial history, continued to entrench an inequality of ownership of the economy, which in turn led to the deepening of divisions in our society, the perpetuation of the casualization of labor, which drove up joblessness. The apartheid system tended to foster investment in capital-intensive industries that cannot provide employment for many. Banks and retail outlets focused on serving the core formal economy. Those in the former Bantustans and townships were largely excluded and underserved. Flowing out of the socio-economic analysis above is the lack of access, appropriate savings coupled with poor financial literacy, consumer education, and consumer protection. That has deepened the class, gender, and race divide. Given that the then political dispensation did not care for the majority of its people, the financial sector developed in same context, paying little attention to the working class and the poor, and little attention to the interests of the downtrodden consumers. The financial sector in South Africa is characterized by high and opaque fees and the need to undergo transformation to be more transparent. The cost-effective financial services are not going to take people out of poverty. In fact, they could deepen their poverty. As defined in the strategy and tactics of the ANC, the developmental state that is under construction is strategic in its orientation, and it has the capacity to lead in defining a national agenda and in mobilizing all society to take part in the implementation, and has an organizational and technical capacity. It is this developmental state approach that must shape the nature and character of the financial sector. Changing the lives of our society as a whole is the imperative of liberation of Africans in particular, and blacks in general. Following the effective social dialogue with economic stakeholders, the financial sector campaign coalition was established and sanctioned by the ANC. The financial sector is a platform for structural change in that key sector of our economy.
Honorable Mtileni, why are you rising?
House Chair, I'm raising on a point of order. Honorable there, I think is missing the topic. He's discussing some other things instead of being straightforward with the topic.
Honorable Mtileni.
We're discussing
order, members.
consumer
Honorable
rights.
Mtileni.
But if you check, not even a single sentence is talking to today's topic.
Honorable Mtileni, can you take a seat? You know
I wanted
that.
to make you aware that this is where you are, that's why.
No, it's not a point of order, it's a point for debate.
Yeah.
Continue, Honorable Mtimunye.
I may miss the point now, Honorable House Chair, but I may not miss the point, Eskalin Wantombela. There's no anarchy out there. There is police that people want. And let's meet at the local government election campaign, Honorable Muteling. You may take your seat.
Honorable Mtileni, why are you rising?
Which anarchy is he referring to? If maybe may assist. Anarchy I refer which one is it?
Honorable Mtileni, can you take your seat? Without making it a dialogue, let me address Honorable.
I think he's being personal.
No, Honorable Mtileni,
He's being
take your
personal.
seat, I'll make a ruling. Take a seat, I'll make a ruling, take your seat.
Now,
Honorable.
Now.
Yeah.
Okay.
Honorable Mtimunye, refrain from direct responding to members who are making some utterances that are point of debates, because that might end up creating a problem in the House. Continue,
Thank you,
Honorable.
Honorable House Chair. The campaign is aimed at intensifying the just fight against reckless and unsecured lending practices that sink our people, especially the workers and the poor, into unsustainably high levels of debt that cause many social problems, devastating households and communities.
Honorable Mtileni.
It mustn't be just as cheap as you put it. You must apologize. I mean, the word anarchy has got its own meaning. I thought maybe you're going to ask him to withdraw the word anarchy. We are not anarchists. That's why I said, who is he referring to? Is he referring to the ANC, which has failed the people for the past 20 years? Or is he referring to himself? Because now he's deviating from the speech.
No, Honorable Zwane, take your seat. Let me address
he's losing the context of today's debate.
In as much as, take your seat so that I can address you. Honorable Mtileni, you can't use the word cheap and referring it to the presiding officer. You are the first person that's supposed to first refrain also from using words that are compromising the decorum of this House. I'm appealing to you. Let's allow Honorable Mtimunye to continue. No, there's nothing that is to withdraw. In as much as I've asked you to refrain from doing that, I've done the same thing with him.
All I wanted to know, House Chair, he said there's no anarchy here. And we meet at the polls. So I was saying, who is he referring to? Is he referring to himself?
Honorable Mtileni, I've addressed it. It's a point for debate. It's a point for debate. Don't subject me to debating it with you. Can you take your seat? It's relevant what you are raising. Continue, Honorable Mtimunye.
The ANC believes that the importance of consumer financial education lies in its ability to improve people's financial well-being. The current financial sector environment has abundant and increasingly complex product offerings. This, combined with a growing range of financial challenges facing households at the macro and micro levels, implies that the enhanced financial understanding and awareness by consumers is essential. Improved consumer financial education reduces information and promotes market transparency, competition, and efficiency. It also has the potential to increase access and demand for financial products. The current draft consumer financial education policy rests on 3 pillars. Consumer financial education is not a substitute for effective consumer protection and market conduct regulation. Rather, it is part of a wider policy approach which includes properly regulating and supervising the financial service industry and protecting individual consumers. Consumer financial education requires a multi-stakeholder approach that is centrally coordinated to ensure the active involvement and cooperation of all. Honorable House Chair, government, schools and financial institutions, industry associations, employers, trade unions, community organizations and non-governmental organizations needs to cooperate.
Honorable Mtimonye. Honorable Isaac, why are you rising?
The obvious, man. I need to hear if the man will have the audacity to take my question.
Okay, Honorable Mtimonye, are you ready to take a question?
Ngiyawuthatha umbuzo wakho esikhaleni kwaNtombela mfowethu.
Honorable Isaac is not ready to take a question. Take a seat. Nah, he's not ready to take a question. Continue, Honorable Mtimonye.
The major outputs, Honorable House Chair, is that the national strategy should be developed taking into account South Africa's realities and international best practices. In addition, activist consumer bodies need to be supported. Online price comparison tools and forums to complain about the quality of services provided provide an invaluable function for the broader community. By applying laws of general and specific application is consent. In consent, the ANC government can strengthen the consumer protection in the country to improve the lives of our people. The Consumer Protection Act is a law of general application that needs to give way to sector-specific legislation that also provide protection to consumers and matters related to it. In this regard, the department and their entities should work together on cross-cutting matters to implement the program of consumer education. One member of the DA asked, why did we not do it before, Honorable House Chair? In my other life, I was a UDF activist and a civic movement activist. I was at the center of coordinating of what was known as consumer boycotts in the 80s. And at that time, the suppressive government, which gave birth to some of the members that are sitting here today, found it problematic.
Honorable Mtimonye, let me recognize Honorable Van Lingen.
Thank you, Chairperson. This member is actually misleading the House. He cannot say that members of the previous regime gave birth to members in this House. He must withdraw, and I insist.
Order members. Order members. Honorable Mtimonye. Did you say the previous regime gave birth to members sitting in the House?
I said some members sitting in this House. And Honorable House Chair.
Honorable Mtileni, take your seat. Take your seat. Conclude, Honorable Mtimonye.
Honorable House Chair, the ANC lives, the ANC leads. I thank you.
Honorable Van Lingen.
Chairperson, Honorable Farrat was on his feet. Honorable Mpambe Sibukwana was on her feet. You are ignoring it and you are not asking the member to withdraw.
Honorable Van Lingen, I recognize you because I thought you wanted to raise something. But
I am raising something. I am questioning why you're not recognizing our members when they want to stand on the point of order.
Let me address you. When you were standing, Honorable Isaac was also standing. And when you got the opportunity, he decided to sit down. And when he was concluding, then Honorable Isaac was down. But I missed Honorable Mpambo Sipukwana. I'm sorry, I missed you. Yeah, I missed you.
Honorable.
No, you are not recognized. I'm acknowledging that I missed you. I'm sorry for that. There's no speaker now on the floor. Yeah, I acknowledge that I might have I missed you. Thank you. Thank you. No, take your seat. Okay. No, Honorable Mteto, take your seat. Honorable Pampos Pugwan.
Thank you, Honorable Nyambi. I would just like to say, in the true name of fairness, I had long been standing here, and for future purposes, can I please urge you to also look on the left-hand side, because this is a consistent thing that's happening from the presiding office. They never look on the left-hand side. It is pathetic, and they know exactly this is a Western Cape side. It is posing some biasness. It is also posing the value of fairness. It is not fair. It is not fair, Honorable Nyambi, and can you please ask them to keep quiet, because you gave me a permission for future. I said I'll be speaking for future purposes.
Honorable Pampos Pugwan. Order. Honorable Zwane, take your seat. Honorable Pampos Pugwan. Can you, order members, can you please, Honorable Pampos Pugwan, withdraw the part of casting aspersion to presiding officers. The second thing, in terms of Rule 46, deliberately making a statement in the House that you know that is false. Of course, I've acknowledged the mistake of not seeing you when you were standing. But to imply that on the left it's only Western Cape, you even know that that is not true, because you have got members that are from the Northwest, that are part of the left. So withdraw the casting aspersion on presiding officers. I don't think it's the appropriate language. Can you withdraw that?
I was voicing my opinion in this regard, Honorable Chairperson, because there is consistency of this practice that is happening all the time. And this is my observation, Chairperson.
Honorable Pampos Pugwan, I'm dealing with two things. You made a statement that you know deliberately it's false. The left is not only Western Cape. That's the first thing. The second thing, we are casting aspersion on presiding officers. So I'm requesting you to please withdraw that.
My observation, Chairperson, has been, this is happening, it has happened previously with Honorable Tau. That's why I'm raising the point of consistency. And it's raising the equality on the way we're being treated. That's why I'm standing up on this point.
Honorable Pampos Pugwan, I've asked you for twice. I'm doing it for the last time. Are you ready to withdraw, or are you not ready to?
What exactly was she withdrawing? What was she withdrawing? I didn't see her.
Sir.
She was standing. What was she withdrawing?
No, we are not recognized. I'm dealing with Pampos Pugwan. No. Take your seat. I'm dealing with Pampos Pugwan.
You didn't see her. That's the proof.
For peace sake, I withdraw.
Thank you. Honorable Minister.
Thank you very much, Chairperson. Chairperson, let me say that I actually found this to be an interesting debate, and I found that the reports that came from the provinces...
Sorry, Honorable Minister. Honorable Julius and Honorable Faber, can you please take your seat? We have already concluded there was no speaker on the floor. Not unless you have got a point of order to the minister. Honorable Faber, take your seat. No, I'm requesting you to take your seat. I'm not recognizing you. I'm saying take your seat. You are not recognized. I'm saying take your seat. Honorable Julius, take your seat. You are not recognized. Take your seat. Honorable Julius, take your seat. For the last time, Honorable Julius, you take your seat. Honorable Julius, kindly withdraw your participation till the end of this session in the House, because we are undermining the order of the chair. I'm not getting to any debate. There's no point of order. Can you leave the House? Honorable Julius, leave the House. Conclude.
Thank you very much,
Honorable Julius, leave
Chair.
the House.
Chair, I'm saying that I actually want to thank the members, majority of the members that participated in the debate, for their contributions. I thought that the reports from the provinces. I'm having somebody shouting in my ear here, Chair.
Honorable Julius. Honorable Smith, take your seat. I'm recognizing you.
Thank you. Thank you very much. Honorable.
No, he's standing on a point of order. I'm recognizing him.
Honorable House Chair. Honorable House Chair. It is very, very dangerous what is happening today in this House. That on which rule did you deny the Honorable Julius a point of order? Because a point of order can be raised on a,
Let me assist you.
Process that happens
Yeah, you have raised
within
it.
the House, or on what an individual said on the, or a member said on the
I'll assist
floor.
you.
Yes.
Take your seat so that I can assist you. There was a speaker that concluded, I missed Honorable Pambosh Pugwane, and then when she raised the point of order, we entertained the point of order. I made a ruling, and then after finalizing the ruling, then Honorable Isaac and Honorable Julius decided to stand up and challenge the ruling. And then from there, no, there was no speaker. That is why I even said, not unless the point of order is to the minister. And then he said, no, it's not to the minister. So, Honorable Julius, I requested you to leave the House. Honorable Julius, can you leave the House? Honorable Julius, you can't speak without even being recognized. Even now, we are not recognized. There's a very clear ruling, you leave the House. Honorable Julius, Rule 37, subsection 1B. The officer presiding may order a member to leave the chamber immediately for the remainder of the day sitting if the officer presiding is of the opinion that the member is in contempt or is disregarding the authority of the chair. We are done. I'm done with your issue. Can you leave the House? Asha, can you please assist us with Honorable Julius? Yeah. Honorable order members, I've requested the honorable member to leave the house, and I'm now invoking section 30, subsection 1. If an officer presiding is of the opinion that the behavior of the member is of so serious a nature that an order to leave the chamber for the remainder of the day sitting is inadequate, the officer presiding may order the offending member to leave the precinct of parliament until the chairperson of the council has announced what actions is to be taken against the member. Let me apologize, Honorable Minister, for that. Order members. Order members. Honorable Gale. Order members. Honorable Gale.
Deputy Chairperson, I'm worried about how we handle matters here. We must be consistent. When the members of the EFF were asked to leave the house and they wouldn't leave the house, security was called. It is very important that we must be consistent, but you asked, with the Honorable Julius, we didn't call security.
Honorable Gale, I was definitely going to do that if he defied, but it was clear that he was getting out. No. Honorable Mtileni, take your seat. Honorable Mtileni. Order members. Order members. Sorry for that, Honorable Minister. Can you continue?
Okay, no, thank you very much. I was trying to say that I thought that most of the debate, the contributions were actually.
Listen, you, but you know my mic is off. You understand? To show that you care less about us. If it was somebody from the ANC, you would say, hey, you just wash your hands. Eh?
Honorable Mtileni, your mic is on. Number 2.
But most of the time I address you, it is off.
Honorable Mtileni, number 1, your mic is on. 2, we are not even recognized, we are just talking. Without being recognized.
The EFF is around. It's coming. Don't worry.
Take your seat.
I'm not threatening you.
Honorable Chair, you have invoked certain rules. I beg you to go and look at the video of this sitting and evaluate your own performance. Because you are not fair. For instance, this Honorable Minister here, he's supposed to sit when I speak. He defies you. He defies everybody here.
I never said he must take a seat. Continue, Honorable Minister.
Thank you very much, Chairperson. Chairperson, I was trying to say that I wanted to thank most of the honourable members, starting with the MEC Somyo, for the interest in reflections about the work that's been done in the provinces. Just to give a little bit of a picture, the situation is that the majority of work to enforce consumer rights through the bodies that are established is taking place in 3 provinces, and I think that's something we need to consider and concern ourselves with. 50% of the cases are in Gauteng, 17% in the Western Cape, and 13% in KwaZulu-Natal. That means 80% are in the more developed provinces of the country. Most of the cases are to do with motor vehicles, with retail, and with ICT, and the majority of the issues are unconscionable conduct, defective goods, and poor quality of service. That is the broad statistics. What I think I've picked out of this, and I didn't have time myself, but the Honourable Dlamini did it very ably, was to outline the rights that consumers enjoy under South African law. And I think that what I'm detecting in this debate is that there is a degree of consensus that those rights are indeed valuable and important, and that indeed we need to move further forward to ensuring that those rights are enforced in South Africa. I just wanted to say in response to the Honourable Mkhanyakude and also to some extent the Honourable Kawule, that it's not true that it's costly, only people with money have redress under our law. The National Consumer Tribunal, anybody can appear before the tribunal. You do not have to have legal representation. The tribunal also arranges for parties to appear through cost-effective platforms like video conferencing and Skype at its own cost, so that consumers do not in fact have to travel to the tribunal in Tshwane. It's also essentially free for a consumer to take their case to the tribunal, which makes it accessible even to low-income consumers. What I wanted to say, though, is that what is evident is that it's not just the formal working of our structures that's important, but also our ability to campaign on behalf of consumers and consumer rights. I gave one example of a campaign that our department is spearheading, because you see the principles that were outlined by the Honourable Dlamini, that it is not legal to provide a product that causes harm or damage to a consumer in South Africa. That's very important for a number of reasons. It's very important because the consumer themselves will lose out if they are the victims of a harmful product. I tried to point out in the case of the paraffin stoves that it was also costly to our governmental structures who had to deal with the hospital costs, who had to deal with providing relief to people who become victims of fires, had to use the fire brigades and all of that. And in addition to that, we've got local producers who are suffering because the competition is from low-quality imported products. And then I said one of the features of our consumer legislation is that small traders are also treated as consumers when they buy from other people. So small traders who are trading in substandard products are also negatively affected because they bear the consequences of passing this on to others. Now, I said we've been trying to lead this campaign. Well, let me say, I didn't hear from the DA speakers. I heard a lot of generalities about the economic climate in South Africa. I didn't hear any specific comments about consumer issues. So let me just say that when we went to Kaya Sands, the DA councillor, Mr. Mafokwane, was more than happy to see us come there, but he didn't have the capacity or the ability to organize a campaign like that. And we're happy that he comes on board and he supports the campaign to get rid of these. I want to say that to the EFF, that says that they are going to lead a charge for radical transformation. That includes that they're going to radically change the balance of forces between consumers and suppliers. Well, I wonder whether the mayor of Thembelihle in the Northern Cape, who has joined the EFF, is the mayor there. Has he joined the EFF? I haven't noticed, because it happens to be my constituency area, I haven't noticed him leading any kind of campaign on these kind of issues. But let me say that this is what we want to do. We want to lead more campaigns around this. This one, I think, is of very great importance to low-income informal settlements. I put out my hand here now and said, why don't we actually work together, and why don't we all work as constituency MPs to take that campaign further forward? What else is being supplied to low-income people in this country that we can conduct campaigns around, where people are getting ripped off to the disadvantage of themselves and to the disadvantage of compliant manufacturers in this country? Let me just turn quickly. Unfortunately, he's not here. The Honourable Esak was the only one who raised any issues around the credit regulator. Well, he mentioned that there's 1.63 billion. I mentioned it, my trillion rand of debt in this country. I mentioned myself, and I talked about the high level of debt and the possibility in the climate that we're going into that there's going to be credit providers that are going to want to cut corners to the disadvantage of consumers. Well, I do hope, because the tradition of his party is that when we tighten the regulations, when we tighten, for example, the affordability assessments, and we hear squeals from credit providers, they're usually the mouthpiece and megaphone for those. I trust on this occasion that won't be the case, because he said something different. Let me also say that in the National Assembly Portfolio Committee this morning, when they met with the with the credit regulator, and they heard the same figure. It was the ANC component that actually proposed that there should be some kind of debt forgiveness program in this country, that we should be reducing the debt of over-indebted consumers in this country. Well, why doesn't this House take it up? And I'd be very interested to see what is the response of Mr. Isak and his colleagues when it comes to something like that. What I really wanted to say, colleagues, is that this is an area where, as I said earlier on, the Constitution says it's an area of concurrent competence. This is an area where we need to work together. This is an area where we need to strengthen consumer protection, and particularly we need to target strengthening of consumer protection for low-income people. The institutions are there. We need to make more use of the institutions, but we also need to take this up in the form of campaigns. Thank you very much for your attention, and I think that this was a great initiative. Thanks.
Thank you, Honorable Minister. That concludes the business of the day. On behalf of the Chairperson and the Chief Whip of the National Council of Provinces, let me thank the Minister, MEC, special delegates, members for this very important debate. Honorable members, you are requested to remain standing in your places until the procession has left the chamber. The House is adjourned.